Or would I? Okay.
Oh, wait, I might be misstating the last name. It's not, it's Dana, but it's not Snodgrass.
Brandon Nelson. Aaron Richardson. Lee Tiger. All right, so Mr. LaRocca, if I could have you come forward, please.
Vince LaRocca, March 25th, 1980.
Thank you, sir. Mr. LaRocca, you are making a first appearance arraignment on a protection order violation incident date in Richfield back on November 14th, 2022. This charge is what is called a gross misdemeanor in the state of Washington. It's subject to 364 days in jail and a $5,000 fine. I had reviewed this, I think, back in November, had found probable cause at that time. I guess December 14th, I'd reviewed it. I did review it again yesterday. I did still find probable cause. Because this is a criminal charge, sir, you have several important rights today, as you've heard me talk to other folks about. You have the right to a speedy and public trial. You have the right to remain silent. You also have the right to counsel. Would you like to be screened today, sir, for a court-appointed attorney?
I'll get an attorney.
Okay, so planning on hiring private counsel.
Yes.
Generally, in that circumstance, we'd be entering a not guilty plea at this time. That'll preserve all of your rights. We're going to do two things. We are going to assign some future court dates. Again, I have entered that plea of not guilty. We are then going to discuss conditions of release. In regards to the future court dates, we are first of all scheduling what is called an attorney pretrial. That's going to be on the 26th of April, 2023. And that's a date for the attorney that you hire to have the opportunity to discuss your case with the city attorney. Okay. Your next mandatory court date, sir, is going to be on the 25th of May, 2023. And that court appearance is going to be at 1:30 p.m. As I stated, it is mandatory, meaning if you failed to appear at that time, a warrant for your arrest could be issued. So at this time, sir, as I did direct the other gentleman, I would caution you, because we are on a recorded record, not to discuss the actual incident. Sometimes those sort of things come up when we're discussing conditions of release. So any attorney next to you would just tell you to make sure you maintain that right to silence. With that said, Ms. Carmi, in regards to conditions of release, go ahead.
Yes, in this case, Your Honor, we are asking that this court impose as a condition of release only no contact with Kelly LaRocca. This is versus our typical request would be, which would be simply to follow no contact orders imposed by Clark County Superior Court. The reason that, and I believe victim Ms. LaRocca does want to speak here, because I think of some hearing date scheduling, there is some confusion as to whether sitting here today, those no contact orders protect her. She will probably have some clarity on that later today. So for the interim, she does fear for her safety and feels like, because this is a DV charge, she wants this as a condition of release on this case, regardless of what's going on in Superior Court. Again, much like the other gentleman, should counsel be hired and wants to talk with me about release conditions, we can later amend once there's clarity on the underlying NCO.
Understood. I'm going to hear from Ms. LaRocca now. Ms. LaRocca, if you'd like to unmute, ma'am.
Yes, Your Honor.
Thank you. So again, we are, just as I advised Mr. LaRocca, we are not going to discuss the incident from back in November. I'm just simply going to be taking information regarding just the conditions of release. You have been listening in, a not guilty plea has been entered, so I'm trying to preserve all of the rights for both sides. But if you would like to be heard regarding release conditions, please go ahead.
I would just ask the court to please impose the no contact order. I can't describe the fear that I have, and I'm just asking that be held until I figure out what's going on with the Clark County case, which I've already submitted another filing for and should hear back on today to figure out what's going on.
Can I ask one question, Ms. LaRocca?
Yes, sir.
It looked to me like there was a parenting plan in place, at least in regards to the police report I saw from back in November. Is that parenting plan still able to be modified in such a way that it can be enforced as well if there is a no contact order?
Yes, sir.
Okay. So, Mr. LaRocca,
I'm just very confused. I haven't seen anything. I have no idea. The only way I found out about this is I was getting a background check run. So I talked to my son and he said that the only thing that he knew was mom said that she got me when I took the bike and put it in the car. So I don't know.
This is again, one of those, like, we're starting to cross over into talking
Okay.
about the fact.
I don't know what
November.
it is.
Okay. So at this point, I am going to impose the no contact order as a condition of Mr. LaRocca's release. Mr. LaRocca did appear today. I think that there was some ambiguity in regards to the address the court had when I recalled discussing this back in December. So I am going to release Mr. LaRocca at this time on his recognizance. He did show up for court today. Conditions of release are to violate no laws, appear at all mandatory court dates. And again, we set the mandatory court date again for the 25th of May at 1:30. Notify the court of any change of address or phone number, and hopefully you updated that with our court staff when you checked in today. Again, I am imposing the no contact order. I'm just going to make sure I have the details of that correct here. So give me just a moment, please. Do we need a date of birth? And if so, do you want to write it on a piece of paper and hand it to me so I can add it?
Yes, I can do that
Thank you.
right now.
I usually add them when it's a condition of release.
Okay.
That's why I'm bringing that up, but I also don't want to say it streaming on YouTube. There. Anything further from Kelly LaRocca at all before we conclude the hearing today?
No, Your Honor. Thank you.
All right, thank you both. You're finished and Ms. LaRocca can log out if she chooses.
How do I get a copy of what I'm being accused of?
So certainly, your attorney, if they file a notice of appearance, can get a copy of the police report. If you're representing yourself, you can also do a public disclosure request directly to the Richfield Police Department.
Okay. So I go to the police department itself.
Did you get a copy of the citation?
Yeah, but it just said a bunch of different things that I could have done, but it didn't say exactly what I did.
Okay. So I would say that you can get a public disclosure request to get a copy of the
Okay.
police report through the Richfield Police Department, or if you choose to retain counsel, once they file a notice of appearance, they can do a discovery request.
Okay.
All right,
Sounds
thank
good.
you, sir.
Thank you.
Thank you. All right, Jeffrey Hall. Morning, sir.
Morning,
If I could have you state your name and date of birth, please, for the record.
Jeffrey Eric Hall, 52980.
Thank you, Mr. Hall. Mr. Hall, you're making an appearance today on. Sorry, we have your infractions on top here. Driving while suspended in the third degree. Driving while suspended in the third degree, sir, is a simple misdemeanor. It's subject to 90 days in jail and a $1,000 fine. Looks like we also have some traffic infractions here that are going to follow along with your case for a period of time as well. So we're not going to necessarily deal with those today. I have reviewed the police reports. I have found probable cause for the charge of driving while suspended in the third degree. Because this is a criminal charge, you have several important rights, including the right to remain silent, the right to a speedy and public trial, and the right to an attorney. Would you like to be screened today, sir, for a court-appointed attorney?
I'll represent myself.
Okay, you'd like to proceed pro se. At this time, are you going to be entering a plea of not guilty?
Yes, sir.
Okay.
Your Honor.
Not guilty plea will be received. I'm going to assign a pretrial conference date. That's going to be a date that you're going to be able to have a court date with this city attorney. I'm also going to get some contact information for you so she can be in contact with you, okay?
Okay.
That pro se, we call it pretrial date, is going to be on the 27th of April, 2023. And that's going to be at 2 o'clock in the afternoon. That is a mandatory appearance because again, you're representing yourself at that time. We're also going to schedule what is called a readiness hearing. The readiness hearing, if you don't resolve the case on the 27th of April, will be the 25th of May, 2023. And that will be at 2 p.m. Again, also a mandatory appearance. Your release conditions are to violate no laws, notify the court of any change of address or phone number. You're not to drive without a valid license. I am releasing you today on your recognizance. You did show up under your own power. You did follow through with the citation. So I am going to find that there's a likelihood you will appear for future court dates. So the city attorney can be in touch with you. Is there a good contact phone number that she can use?
Yeah, it's 360-213-4047.
And because occasionally they are sending documents back and forth, is there an email address that we can
Yeah.
write on here?
It's solidcrete, CRETE, construction @gmail.com.
Okay. And so solid, SOLID, Crete, CRETE, construction, normal spelling @gmail.com.
Correct.
Okay. All right, sir. We're going to get you some documents. We've accepted the not guilty plea. You have your future court dates. We'll get them to you over by the door. Once you have them, you are free to go. Okay. Thank you, sir. All right. Tyler Burrows.
And do we have Mr. Busby? He'll be the prosecutor on this one.
We do not have Mr. Busby. So Mr. Burrows, we're gonna have to wait a minute or two. The prosecutor is not quite available yet. Mr. Busby. Okay, so just another minute, hopefully, sir. Thank you.
I'll reach out.
Thank you. So do we have just no one, the jail hasn't brought anybody over yet? Oh, Brandon was in a, okay. Oh, okay. Well, I will then just bide my time.
Yeah. The calm before the storm.
Yeah. Although one of the things, when I was preparing the docket, there's not a lot of probation stuff for this afternoon. I was surprised when I saw the numbers. I was thinking, you know,
Yeah.
35 people for probation reviews, and it's only like, but it's the private retained stuff is so big.
There's a lot of readiness, but also, especially this morning, it's like a lot of cases for the same person. So at
Yeah,
least it's not,
okay.
it doesn't look as bad as,
They're not all individual.
Yeah.
Okay, that makes sense.
yeah.
Are we sounds like we're resolving a lot of them this afternoon.
Yeah, but at least out of 8 cases with one attorney, 4 will be resolution. So. Yeah. Try and keep the summer calendar clean. Just kidding. Just kidding. Good morning. When I can.
So it looks to me like, Carol, that we have a lot of contested hearings this afternoon, but no mitigations. Am I right about that? So no one I can call. I'm so good at my phone dialing. All right.
And I
could. I
Neither.
probably could dial faster if I dialed randomly.
And I think we'll have officers on at least 2 of the.
Yeah, it looked that way.
Maybe 3. Okay.
Mr. Busby, can you hear me?
I can, Your Honors. For some reason, my camera is not working on this computer.
Yeah, I see something blurry, but the good news is I know your voice over the last few years of knowing you, so I know it's you. We have Mr. Burrows present in the courtroom. I know that this is a conflict case with Ms. Carmy, so are you ready to proceed with his arraignment?
I am, Your Honor.
Okay, Mr. Burrows, if you'd come up now, sir. And when you come up here, sir, I just need you to state your name and date of birth, please, for the record.
Tyler Burrows. Date of birth 10/17/93.
Okay. Mr. Burrows, you are making a first appearance arraignment, sir, on a charge of what is called assault in the 4th degree. I believe this is an assault in 4th degree domestic violence. It is. Assault in the 4th degree domestic violence, sir, is what is called a gross misdemeanor. It is subject to 364 days in jail and a $5,000 fine. I have reviewed the associated police reports on the case and I have found probable cause. Because this is a criminal charge, sir, you have several important rights today, including the right to remain silent, the right to a speedy and public trial, and the right to an attorney. Would you like to be screened this morning, sir, for a public defender?
Yeah.
Okay. I'm going to ask you just some questions about your income to see if you qualify. Do you receive any manner of state assistance at all?
No.
Okay. Do you have, are you currently employed?
No.
Any income?
No.
Okay, I'm going to find you do qualify for a public defender. Court will assign. Okay, court will assign Mr. Campbell. What we're going to do, Mr. Burrows, is Mr. Campbell is dealing with our 2 folks that are in custody this morning. I want him to have the opportunity to speak to you before you come back up in front. So if you want to have a seat, we'll give your file to Mr. Campbell and he'll be out to talk to you, okay? Thank you, Mr. Burrows. All right. So maybe when Brandon comes out, Jacob, if you could just give him that packet. I want to know Mr. Burrows is in the wait. While we're waiting for Mr. Campbell in the jail booths, do we want to address the 3 remaining arraignment cases right now, Ms. Carmy?
I looked at those and I did look at those just now, and based on the conditions I would have requested had they appeared, I would just be asking for warrants in the standard amount.
I have some concerns on Mr. Nelson's case, but we'll probably get to that one.
Okay, that was one that was kind of borderline for me.
So Judge, if it's acceptable to you, I have a handful of dismissals that I'm going to be working on, just getting the captions done while you go through those guilty pleas relative to this hearing, if that's
Totally fine. Mr. Koskanemi, can you hear the court, sir? As usual, our audio, which is always tricky with the jail where they can hear us, but we can't hear them. Mr. Koskanemi, I'm gonna give it just a minute. We'll see if we can get you on here in a second, okay?
And just, we had no difficulties in speaking, so he should come back on, I would hope.
And just to let you know, Mr. Campbell, I don't have a PTA.
I need the PTA, I'll
The
hand it up in just a
PTA for the
moment.
numbers. Okay.
Yes, just for in fact, I can just buzz through the captions real quick on the numbers and then I can hand that up.
Okay. I'm just gonna try to do this in chronological order, I think.
I
It's gonna
can-
make the most sense.
I can work on the dismissals while you guys get.
Oh,
going.
that would be very helpful. Do you have the PTA so you don't need a
Yep, I
caption?
do. So you can hand that up to Judge and I'll work on that paperwork. Yep.
Need some anyway, so.
Thank you.
Yes, Judge.
All right, Mr. Koskanemi, let's try it again. Can I have you state just your first name and we'll see if we can hear you?
Uh-oh.
Yeah. We did it a couple times to where it kicks on after 30 seconds or so.
Yeah,
But it feels like I'm hazing the person because I keep asking them the same things again and again. All right, Aaron, let's go try it again, please. Yeah, he's not muted, but it's just we don't have any audio. Oh, okay.
it's just interesting deal because he wasn't muted when we were in our breakout room.
No, and what we have noticed is we haven't had issues in the breakout room. We've had issues. We thought initially it was issues when they transitioned back to the main docket, but he's been back on for 7 or 8 minutes.
Yeah,
And thank you.
Can you hear me now?
Oh, we can't hear you,
I
Aaron.
can hear you now, Aaron. Thank you for asking again. Can I have you state your name and date of birth, please, for the record?
Aaron Joe Koskanemi, March 1st, 1997.
Thank you. Appreciate that. I always appreciate the indulgence of folks. So, Mr. Koskanemi, it looks to me like we have a global resolution on your cases that are going to involve dismissal of 5 different cases. It looks to me like you are entering a plea of guilty to failure to stop or obey an officer, 1 count of driving while suspended in the 3rd degree, and 1 no contact order violation. Is that your understanding about what's happening today?
Yes, Your Honor, it is.
There's one other, it's hard to see, it's down below with the cause number, one other driving.
Oh,
while
1
suspended.
other driving while
Yes,
suspended
Your Honor.
third
So
degree.
2 total counts of driving while suspended in the 3rd
Okay.
degree.
Mr. Koskanemi, have you had plenty of time to talk to Mr. Campbell this morning regarding what's going to take place today?
Yes, I have, Your Honor.
Do you need any additional time to speak to him before we get started?
No, Your Honor.
Okay. If during the course of the plea today, you need additional time, wave your hand, get my attention, and I'll absolutely allow you additional time to speak to your attorney. We're going to go through these. I'm going to try to do them in chronological order. I think I'm missing one statement of defendant on plea of guilty.
Let me walk back in the office and get that, Judge.
Yeah, because I have 3 JNSs and 3 statements, and I need 1 more JNS and 1 more statement. I think it's on one of the DWS 3s to give you a hint, Mr. Campbell. No. I think I know what it is. Is there a DWS 3 with the failure to stop, obey an
Yes.
officer?
Under 936.
All right. So it's 4 charges, but there's only 3 cause numbers. Mr. Campbell, if you can hear me, there's nothing else to find back there. I figured out the mystery of why.
Very well, I don't have another.
I figured out the mystery, like, why is there not a cause number here? And it's, oh, it's the same one. Okay.
And here are the five, this is the reverse project in time.
Okay, thank you very much. All right, we're gonna get through this together. Okay, so Mr. Koskanemi, the first charge we're gonna be entering a plea on is cause number 1A0262-391. This is a charge of driving while suspended in the third degree from back in February of 2021. Just to make sure, you're 26 years old, sir,
Yes, Your Honor.
and you've completed some college, it looks like, perhaps?
Yes, 3 years, Your Honor.
Okay, got it. The charge of driving while suspended in the third degree is what is called a simple misdemeanor, sir, subject to 90 days in jail and a $1,000 fine. In entering your plea today, you're giving up several important rights, though, in doing so. You have the right to a speedy and public trial by an impartial jury in the county where the crimes alleged to have been committed, the right to remain silent before and during trial, and the right to refuse to testify against yourself. You have the right at trial to hear and question the witnesses who testify against you, the right at trial to testify and have witnesses testify for you, and these witnesses can be made to appear at no expense to you. You're presumed innocent unless the charge is proven beyond a reasonable doubt or you enter a plea of guilty. As I discussed earlier, there is a pretrial agreement that I am holding up. Do you understand the court does not have to follow anyone's recommendation as to sentence, but can sentence you up to the maximum authorized by law?
Yes, Your Honor.
Okay. Court can have you on probation for a time frame of 2 years, have you pay cost, fees, and assessments as authorized by law. If you're not a U.S. citizen, a plea can result in immigration or deportation issues. To the charge of driving while suspended in the third degree, taking place on February 14th, 2021 in the city of Battleground, how do you plead?
Guilty, Your Honor.
Are you entering the plea freely and voluntarily, sir?
Yes, I am, Your Honor.
Has anyone made any threats or promises to get you to plead guilty?
No, Your Honor.
Factual basis reads on or about February 14th, 2021 in the city of Battleground, Washington. I did operate a motor vehicle with notice and while suspended in the third degree. Is that a correct statement, sir?
Yes, Your Honor.
Will accept the plea, find it knowing, intelligently, and voluntarily made after advice of rights and advice of counsel.
One thing about the sentencing, judge, I haven't noted how much credit for time served just because of the way that the holds for all these matters, and I'll just speak to that, I guess, when we get to sentencing.
Sounds good. Okay, Mr. Koskanemi, our next charge, which you're entering a plea to, is a domestic violence no contact order. This is cause number 2A0. Madam Clerk, let me ask you, is it easier for me to do all of the guilty pleas and then do all of the judgment and sentence, or would you like me to do each judgment and sentence following each guilty plea? All right, let's do it that way. Totally fine with that. So the sentence is as follows on 1A0262-391.
And Judge, just procedurally, did you want me to give a brief argument on the sentencing then before we proceed on all the sentencings, or do you want me to do that at the end? It's up to you. I just know that the client has a right of allocution before sentencing, and that's the only reason I bring it up.
No, I think you're right. Why don't you do it right now? And we'll
Okay.
do that on all of the cases.
Yes.
So what I'll probably do is I'm going to hear from Ms. Carmy universally.
Yep.
And then I'll hear from Mr. Campbell universally, and then we'll hear from Mr. Koskanemi if he chooses.
Is that okay? Here, I can fill it out. Okay.
Sorry, Judge, we're just getting our paperwork.
So Ms. Carmy, if you want to address perhaps the universal decisions that have been made in this case in regards to resolution, if you want the court to hear anything about that.
Yeah, and we're asking the court to follow the recommendations. I think in total would be 21 days in jail for the things that defendant is pleading guilty to. This was a compromise given I think some mitigating factors in Mr. Koskanemi's case and certainly with the DVNCO, that one in particular, the city will be handing up to you a notice of ineligibility to possess firearms, which is just statutory given his guilty plea. So we'll be filling that out now. But otherwise, we think it's a fair resolution. given the underlying charges and again, some mitigating factors.
Mr. Campbell?
And Your Honor, certainly the record that Aaron has brought before you is one of a lack of approaching judicial administration in the right way. And mitigating that fact is he has a traumatic brain injury he was struck by a drunk driver in 2019. He also is catastrophically disabled with some mental health issues, including schizophrenia. He's gotten stabilized while in the jail. He's on antipsychotic medication currently. Did we lose him?
I'm here.
Nope, still here.
Okay, sorry. And so he's really advocated for himself. He has not enjoyed this time in jail, which I think would be relevantly appropriate, and doesn't want to go back. He's engaged with reentry. He has initiated some mental health treatment while in the jail that I'm hopeful he will be able to continue, and he is of the belief he's going to be able to continue when he gets out. The no contact order violation asserts that he was under a blanket in a car in a consensual kind of contact, which doesn't make it appropriate to do. It just mitigates the whole circumstance here. I think it was difficult. He's kind of in a situation where he's easily, he's just subject to making real poor decisions or being, influenced because of his mental health and TBI. And so he has a plan in place for staying away from Ms. McMahon. That's going to be something that is a part of this sentence. I do question, I think that the no contact order originates in district court, so I don't think we have to do anything on the no contact order formally. I believe I put in the DV no contact order judgment and sentence as a proposal between the parties that was agreed that he's not to have any contact per the relevant orders. And so I think that's a sufficient protection for community safety. He has about $100,000 in healthcare debt, $5,000 in debt and credit card debt, and really no meaningful work history to note to the court. I mean, he is chronically and habitually indigent, and just showing kind of the inconsistencies of his past. I mean, my hope is that he stabilized himself at this point in the jail, is able to then get out into the community and stay in access with mental health treatment. And, that can be very difficult. It can take 2 months to get in to see a psychiatrist out in the community, sometimes more. You might have to call, 5, 6 different entities to be able to get that help. And that's really a detriment to the community. That's something that is out of Mr. Cuscanemi's control. And so I know that he has some family support in the community. So I'm hopeful that he'll avail himself of that. He's understanding that even these driving while suspended cases, because of his TBI and his sort of lack of ability to keep all the balls in the air, could result in him going back to jail. So I think he's of the opinion that driving is just not going to be a suitable thing for him. I mean, he's got a lot of impediments and barriers that he's working against at this point, Your Honor. And so we just ask you to impose those conditions that are outlined in the pretrial agreement. Mr. Cuscanemi, you have an ability to speak to the judge if you'd like, but you do not have to. Do you wish to speak?
I'm fine. I believe you stated it properly, Your Honor. Sir. Thank you, Randy.
All right, cause number 1A06 262-391, 90 days in jail with 87 days suspended, 3 days to serve. Again, we'll do a calculation at some point for credit time served, or the jail can. $1,000 fine. I am suspending all $1,000 pursuant to Blazina. As Mr. Campbell said, I believe Mr. Coscanemi is indigent and is subject to that.
Well, one final thing on the sentencing, Judge. The reason that I didn't mark the credit time served is I didn't want to make a decision for Your Honor. But from my perspective, he's only been held on one battleground matter, but he's been held since the 23rd of March. So he has 21 days of credit, but it's only on one case. And I think in fairness, just the kind of global resolutions anticipates that the credit would be applied to separate cause numbers, because the effect was just more of an administrative one for the court's benefit to save costs as opposed to putting holds on every case.
And he's not being held on anything else.
He is being held on other matters, but if you're, so I don't exactly know what to do about that. Aaron, have you already been sentenced on either of the district court cases that you have in Clark County District Court?
Yeah, I believe yeah, I think so.
Your Honor has the technical authority to have these sentences served concurrent to those district court cases. I don't know exactly how to apply credit in this situation. I'm just being frank with the court about it.
The city's in the same boat, which I think is why this the city's request would be that we do indicate on each judgment and sentence credit time served. We may want to clarify credit time served for any, and I certainly could add all the cause numbers on each JNS. But I think the problem is because of that other hold, I don't think it's gonna hit that
He
21.
hasn't been sentenced on the felony yet, so the felony case will be sentenced tomorrow.
I'm showing that a warrant was served on March 23rd. On the 24th, then we put bail on one of our cases.
On the,
On the 30th, then we release our hold on all cases.
and that was my understanding as well, is that, and at least jail records show that he was released on ours at that last appearance.
So what's intended by the parties, though, is that he get 21 days and have served 21 days. I mean, that number wasn't arrived at magically. It was
Correct.
arrived at because that's the time he's been in. So I think the easiest thing for us to do is to say on each one of these cases, we will just give credit time served.
And that's
That's fine.
defense's perspective. I mean, really,
Yeah.
even the release of the hold was not anticipated to release him from custody. It was more of just a.
All right, so again, 90 days, 87 days suspended, 3 days to serve, credit time served for 3 days, 1,000 with all $1,000 suspended pursuant to Blazina. No criminal violations, not to drive a motor vehicle without a valid license, bench probation for 24 months. I'm not going to go ahead and set a review on this case. I think with this, the substantial portion of the case has been completed. Certainly probation will monitor any future new law violations. Okay.
This is something we don't contact over basis, the firearms restraint.
Okay. Next case that we'll be doing the plea on is 2A06191761. This is a charge of a no contact order, domestic violence, no contact order violation. Mr. Koskanemi's identified himself. He's 26 years old. He's completed 15 grades in school. Mr. Koskanemi, you're able to read and understand the English language. I think I've forgotten to ask you that.
Yes, I can, Your Honor.
Okay. On this charge, you are giving up the rights associated with trial. I will go through those rights with you. The right to a speedy and public trial by an impartial jury in the county where the crime is alleged to have been committed. The right to remain silent before and during trial, and the right to refuse to testify against yourself. The right at trial to hear and question the witnesses who testify against you. The right at trial to testify and have witnesses testify for you, and the witnesses can be made to appear at no expense to you. The right to be presumed innocent unless the charge is proven beyond a reasonable doubt or you enter a plea of guilty. And the right to appeal a finding of guilt after trial. You understand those rights, Mr. Koskanemi?
Yes, Your Honor, I do.
You understand that in entering your plea today, you're waiving or giving up those rights.
Yes, Your Honor.
This charge is what's called a gross misdemeanor. It's subject to 364 days in jail and a $5,000 fine. You understand the court does not have to follow anyone's recommendation as to sentence, but can sentence you up to the maximum authorized by law. Place you on probation for a time frame of 5 years, during which time you can pay cost, fees, and assessments as authorized by law. Box L is checked, which talks about the court imposing a mandatory $15 fee. Box M is checked that you're not able to possess, own, or have control firearms. Do you understand that, sir?
Yes, Your Honor.
And are you in agreement with that?
Yes, Your Honor.
To the charge of a no contact order domestic violence taking place on November 17, 2022 in the city of Battleground, how do you plead?
Guilty, Your Honor.
Are you entering this plea freely and voluntarily, sir?
Yes, Your Honor.
Has anyone made any threats or promises to you to get you to plead guilty?
No, Your Honor.
Factual basis states on or about November 17, 2022 in the city of Battleground, Washington. I had in-person contact with the protected person,
Satira McMahon.
Satira McMahon, my former intimate partner, in violation of a validly served no contact order. Is that a correct statement, Mr. Koskanemi?
Yes, Your Honor, it is.
I will accept the plea, find it knowing, intelligently, and voluntarily made after advice of rights and advice of counsel. Pursuant to plea, I am also signing off on the notice of ineligibility to possess a firearm. 2A06191761 DV no contact order violation. 24-month suspended sentence. 10 days, 364 days with 354 days suspended for 10 days to serve. Credit time served for 10 days. A $5,000 fine with all 5,000 suspended. Bench probation for 60 months. Conditions, no criminal violations. Obtain a mental health evaluation and comply with recommended treatment. Continued no contact with Satira McMahon per order in place. We are going to set a review date for this matter, Mr. Koskanemi, on the 13th of July, 2023, to see where you are on your mental health evaluation and treatment. That will be a mandatory court date in the Battleground Municipal Court at 1:30 that day. Do you understand that, sir?
Yes, Your Honor, I do.
Aaron, if you forget your court date, you can call the Battleground Municipal Court. You can search online. There's a mechanic that will tell you your court date, or you can call my office.
Okay, thank you, Brian.
All right, Mr. Koskanemi, our final case for plea is 3A0276-936. This is count 1, failure to stop or obey law enforcement, and count 2, driving while suspended. I'll note all of the information about Mr. Koskanemi is the same. He's previously answered that he is able to read and understand the English language. To these 2 charges, sir, both of which are simple misdemeanors subject to 90 days in jail and a $1,000 fine, you do have the following rights: the right to a speedy and public trial by an impartial jury in the county where the crime is alleged to have been committed, the right to remain silent before and during trial, and the right to refuse to testify against yourself. You have the right at trial to hear and question the witnesses who testify against you, the right at trial to testify and have witnesses testify for you. And the witnesses can be made to appear at no expense to you. You're presumed innocent unless the charge is proven beyond a reasonable doubt or you enter a plea of guilty, and you have the right to appeal a finding of guilt after trial. Do you understand those rights, sir?
Yes, Your Honor.
And do you understand that in entering your pleas today, you're waiving or giving up those rights?
Yes, Your Honor.
Again, we've already discussed that the court does not have to follow anyone's recommendation as to sentence, but can sentence you up to the maximum authorized by law. In this circumstance, during a 2-year term of probation, the court can impose cost, fees, and assessments as authorized by law.
Yes, Your Honor.
To count 1, failure to obey a law enforcement officer taking place on March 23rd, 2023 in the city of Battleground, Washington. How do you plead, sir?
Guilty, sir, Your Honor.
To count 2, driving while suspended in the 3rd degree taking place on the same date and the same location in Battleground, Washington. How do you plead?
Guilty, Your Honor.
Are you making these pleas freely and voluntarily?
Yes, Your Honor.
Has anyone made any threats or promises to get you to plead guilty?
No, Your Honor.
Factual basis states on or about March 23rd, 2023 in Battleground, Washington, I intentionally failed to stop my motor vehicle. I was operating while with notice on or about March 23rd, 2023 in Battleground, Washington, I intentionally failed to stop my motor vehicle. I was operating while or with notice I was suspended in the 3rd degree when signaled to stop by a law enforcement officer. Is that a correct statement, sir?
Yes, Your Honor.
We'll accept the pleas, find them knowing, intelligent, and voluntarily made after advice of rights and advice of counsel. On 3A0276-936, count 1, failure to stop or obey. 90 days in jail with 85 days suspended, 5 days to serve. $1,000 fine with all 1,000 suspended pursuant to Lazina. On count 2, 90 days in jail with 87 days suspended, 3 days to serve. $1,000 fine with all 1,000 suspended. That's a total of 8 days in jail with credit time served for 8 days. Conditions of sentence: no driving without a valid license, 24-month bench probation. I am not going to schedule a review on this case. I think the only case with substantive review conditions is the DV case with the mental health condition. That'll be the one the court's reviewing going forward. Certainly, Mr. Koskanemi is still on probation. If you were to commit new crimes, all of these are subject to a probation violation. Pursuant to pleas that Mr. Koskanemi has entered today, I am signing a notice of dismissal on 2A010445494. That's a creative 9. I'm in there. Okay. Also signing an order of dismissal on 2A0535237. Also signing a notice of dismissal on 1A0664523. And finally, a notice on 1A0607596. All dismissals in the interest of justice pursuant to pleas that Mr. Koskanemi has previously entered.
Or dismissal possibly,
There is, sorry, there's one left at the end, 1A0560052. Again, also in the interest of justice, stuck to the other ones and signed. All right, anything further on Mr. Koskanemi's cases from the parties?
Just Aaron, if you have difficulty accessing mental health treatment, you should reach out to my office. I may be able to help you with that.
Okay, thank you very much, Mr. Campbell. Thank you.
Good
Your
luck,
Honor.
Mr. Koskanemi. We wish you well, sir.
Thank you very much, Your Honor.
All right,
You want to do Mr. Nelson?
yeah. I am going to ask, I know people in the courtroom, I think, are here for the 10 o'clock portion of the docket. I am going to read off the 3 matters we have. Is Brandon K. Nelson in the courtroom? Is Aaron Lee Richardson in the courtroom? Is Lee Joseph Tiger in the courtroom? No response, no one waiting, it looks like, in our Zoom waiting room. Let's go ahead to Brandon Nelson, 3A0035603. This is a negligent driving in the first degree charge from back on March 7th, 2023. I do acknowledge it looks like the officer did not cite him directly, but perhaps mailed a citation to him.
Correct.
We don't have that returned though. And it looks like the mailing did take place back on the 29th of March. So certainly 2 weeks ago. I have reviewed the police report for the charge of negligent driving in the first degree. I have found probable cause. This matter was scheduled for 8:30 this morning. It is now 9:44 a.m. I find that Mr. Nelson has not appeared. Go ahead, Ms. Carmi, in regards to requests via warrant.
Yes, Your Honor, in this case, we will leave it to the court's discretion on warrants, certainly, given that there was alcohol involved in a collision that did result in at least allegations at this point of someone going to the hospital. The city could certainly understand a warrant beyond the standard.
I'm going to authorize a warrant. I think that this could still theoretically be a vehicular assault, depending on the nature of those injuries. So I think that this is on a borderline, potentially a felony.
Yeah.
I am going to impose, I'm going to find that Mr. Nelson has failed to appear. I'm going to impose a warrant in the amount of $3,000 on this matter. Next matter is Aaron Lee Richardson, 3A091968898. This is a person, I think, who had reached out to the court last week about the ability to get here. It's a license plate violation, flip license plate violation, or false registration violation, simple misdemeanor. I am gonna find that last week we sent over Ms. Richardson to appear this week, no response. I'm gonna issue a warrant in this matter in the standard amount. Last matter from the morning docket, a Lee Joseph Tiger, 3A0226-252. Mr. Tiger was scheduled today for a charge of theft in the 3rd degree. I did review the police reports in his matter. I did find probable cause for that charge. Note the failure to appear, Ms. Carmi, in regards to conditions of release.
Yes, this is also a situation where the citation was mailed. By our review, it was mailed to the last known address per Department of Licensing. Given the underlying charge, we do also note, I guess, Mr. Tiger has a current active warrant out Clark County. However, we would ask for a warrant to issue in the standard amount at this time.
Warrant will be authorized in the standard amount for Mr. Tiger. Do we have someone in the other jail booth at this time?
No, not at this time.
So in the 15 minutes before our 10 a.m. docket, do we want to take our morning recess at this point?
Sure.
All right, court will be in recess until 10 a.m. to allow attorneys to talk to folks. We'll be back out here at 10 a.m. I think that's our conflict time, so we'll do Ms. Thayer first.
All right,
Thank you.
we're in recess. Really not one time for like a balance on for the element. It used to be really big when you ran some of the council, maybe the council chair has to evaluate. So the report ready to send, I'll see what I can do now. Let me make it back.
Oh, this is not ready to go up on our end, but I'm gonna go see if I see that.
It's not yet written. Can you grab all of these files? They're costing me.
Section would they be in?
Driving what I had them.
He just handed me that stack of paperwork.
If
not a
you
folder.
go back to his office and see if he has all of Eric's files, I think it's around one piece. Thank you.
For everybody new that just has been coming in the courtroom, we can just make sure your phones are on silent, please. Thank you.
And if you let me show you why. Ladies and gentlemen, Do we have a Ralph Greer R in here? Okay. Is your attorney appearing via Zoom, or is he going to be here? Stephanie. Becky is supposed to be there. Okay. I do not see her on Zoom yet. I do have Judge Thayer ready, so as soon as the attorney is here or on Zoom, we can go ahead and go. Oh, Stephanie, was it Stephanie Radecki? Yeah. Okay, she is on Zoom. All right. Mr. Greer, if I can have you come up to the podium, please. Good morning, Judge Thayer.
Good morning, Ms. Landwehr.
Okay, and I have attorney, Ms. Radecki. If you could please, unmute and have your camera.
Good morning, Your Honor.
I'm going to have you stand right there at the podium. Okay. Okay, thank you. All right, Your Honor, we can go ahead and go.
Thank you. All right, it looks like we are hearing Mr. Greer. Is that how we pronounce your name?
Yes.
Looks like you're appearing this morning on a DUI charge. DUI is a gross misdemeanor that runs with it a maximum penalty of 364 days in jail and a $5,000 fine. You have the right to remain silent, the right to a speedy trial, the right to an attorney. It looks like you have an attorney representing you this morning. And Ms. Radicki, have you filed a notice of appearance on this matter?
I have not, Your Honor. This is actually Robert Anderson's case. I am just covering for him this morning as he is in several different courts.
Okay, understood. Are you ready to proceed forward with arraignment at this time?
I am, Your Honor.
Okay, go ahead.
Thank you, Your Honor. We would like to waive formal reading of the charges, enter a plea of not guilty, and set it for a future date. Also, review release conditions.
Okay, I have reviewed the probable cause statement. I have found probable cause. Go ahead, Ms. Carmi, with regards to release.
Yes, Your Honor, thank you. In this case, we will note for the court, no prior DUIs, no prior criminal history. We are asking on a discretionary basis that ignition interlock be imposed along with standard DUI conditions. This is simply the result, although it is not mandatory under the law, it's a result of the alleged BAC level in this case, as well as the fact that multiple bystanders have, at least in these are allegations at this point, had to alert oncoming traffic of this driver to avoid head-on collisions. So had that not occurred, had there not been good Samaritans essentially in the right place at the right time, this would likely be a much different story we're hearing. And again, because of that and out of a community safety concern, we are asking for that discretionary ignition interlock.
Okay, Ms. Radicki.
Yes, Your Honor. Mr. Greer's car was totaled during the incident. He is not able to drive. He will not be driving. His wife has indicated she's going to drive him around when it's needed. If he ever does get to the situation where he's in the position to drive, then he will install an ignition interlock. But at this time, it's just not applicable. So I would request that the court not impose the ignition interlock at this time.
And Your Honor, in that case, then we would ask for random UAs if ignition interlock is not viable, because we do think that there is a community safety concern here that certainly all of us have a duty to protect.
Mr. Greer, how old are you?
66.
Okay, I think I understand the seriousness of the nature of the allegations. We have a single vehicle collision here. Sounds like it could have been something worse, although the facts provided in the probable cause statement are pretty slim with regards to the actual driving. There's just sort of a conclusory statement that there was some observed reckless driving immediately prior to the crash. I don't have any information beyond that except what Ms. Carmi provided. I think given the age of Mr. Greer and his lack of criminal record, I'm not inclined to order random UAs. I will release him on his own recognizance. I will order ignition interlock installation within 5 days, but he can sign the declaration today indicating that he won't be driving a vehicle. So Mr. Greer, you're going to be released today on your own recognizance. Given the seriousness of the allegations, if you do drive a vehicle again, the court is going to require you to install an ignition interlock in your vehicle within 5 days of coming into possession of that vehicle. Sounds like you don't have a vehicle to drive at this time. So I'm going to have the city provide a declaration to you that basically indicates that you will not be driving a vehicle, and if and when you do come in possession of a vehicle, you install that ignition interlock device. Do you understand that?
No, I'm sorry, I didn't hear that very well. Do you have a short version?
Yes. You're going to be released on your own recognizance today. The conditions that you are to abide by while this case is pending are to violate no laws, so remain law-abiding while the case is pending, appear at all mandatory court dates, notify the court of any change of address or phone number. You are not to consume or possess alcohol or non-prescribed drugs while the case is pending. You are not to drive without a valid license and insurance. You are also not to drive a vehicle unless it is equipped with an ignition interlock device. My understanding from your attorney is that you do not have a vehicle right now. Is that correct?
I have two vehicles at home and my wife has a vehicle.
Okay, so if you intend to drive a vehicle yourself, you will need to install an ignition interlock device in that vehicle. If you can get around without driving, meaning you can have your wife drive you wherever you need to go while the case is pending, that's fine. I'm going to have you sign a declaration right now, which is essentially a promise to not drive a vehicle while the case is pending unless it has an ignition interlock device installed in it. Do you understand that?
Yes, thank you for repeating that.
Okay. All right. Your next court date is going to be May 18th at 2 p.m. And then Ms. Radicki, I'm going to set the attorney-only pretrial conference for May 3rd,
Okay.
3:30 p.m. Okay. Do we have any questions?
No, thank you.
Okay.
So just to clarify, Your Honor, this time it does sound like there are operable vehicles in his control. So we would be, the city would be looking for that declaration of interlock installation within 5 days. Is that Your Honor's ruling?
Yes. So my understanding from his attorney is that his wife is planning to drive him around. Is that the case, Mr. Greer? Are you intending to get rides from your wife while this case is pending, or do you intend to drive a vehicle? I can't hear.
I know for sure my wife can take me most places. I would like the opportunity to get the device on your leg and go on some work-related trips.
Okay, well, if
So-
that's the case, then you will need to install an ignition interlock device within 5 days. Provide proof of that to the court.
And Your Honor, just so I can clarify, and I know as I'm, the defendant is standing in front of me, so I may be hearing things that are harder for others to hear. What he just stated was that he wants to get the device on his leg. And I'm assuming he's referring to a scram monitor of some sort rather than a device you blow into. So I'm just relaying that to the attorney and to Your Honor, since I'm here in court with him.
Okay. Well, Mr. Greer, I'm not ordering you put a scram device on your leg.
Okay.
I'm not ordering that. That's pretty costly, and that's just a more intensive release condition than I think is necessary here. The only thing that I am ordering is that you put an ignition interlock device in any vehicle you intend to drive. And so that is also known as a blow and go device. You can talk to your attorney about that. You can talk to your attorney about how to get one of those installed. You will need to install that within 5 days, business days of today, and provide proof of that to the court. So it sounds like you do have a need to drive a vehicle, that your wife can't take you everywhere. And so if that's the case, you will need to get that device installed. I'm not asking you to put or ordering you to put any ankle bracelet on or submit to any random UAs. I'm just ordering you to install a device in your vehicle so that we can ensure when you drive that vehicle, you're not under the influence.
Okay, thank you.
Okay, thank you. Any other issues we need to clear up?
Nothing
No,
but
Your
this,
Honor, not. Oh, not from the
Sorry.
city.
not from
Okay.
defense.
All right, then I'll sign this and send this over to you, Ms. Landwehr, right away.
Excellent. Thank you, Your Honor.
Okay, and Mr. Greer, we'll see you back on May 18th.
Thank you, Your Honor.
And then you can just wait. You can wait right at that table and the court will give you paperwork. Yep, right there. Yep,
Thank you.
yep. Yep.
I'm gonna go look at it then. And then you read this to me as a first level prosecution treatment, I think so, but. Usually it says it in a different way. But if it's opting for the third, maybe opting for one, so I think that's. I want to draft the paper if I want to. It's 2.1 of the recommended freedom, but I think it's often for the purpose, so I think that all the issues. Well, the change and then I'll try and work with the deadline. So I just wanted to be sure I was pretty. And then on the result. Yes, so that's great, thank you.
All rise. Court's now in session.
Thank you. You can be seated.
So Judge, we have the Shane White matter, which is in custody. I think I provided everything to you on that.
Mr. Wyden, you can hear the court. Can you state your name and date of birth, please?
Shane White, 4287.
Thank you, Mr. Wyden. We do have your attorney, Mr. Campbell, present with us here in court. Go ahead, Mr. Campbell.
So, Your Honor, this is a matter that has a commencement date for today. There's a speedy trial filed and speedy trial waiver filed at our past hearing for a commencement date of April 13th, 2023. And so we're asking to set this matter out 30 days to the May 11th date. I kind of drafted, anticipating that Your Honor may be amenable to this, a return to court with all of the conditions that were previously on the prior return to court, with a return appearance either at 8:30 if the client's in custody, or at 10 if he's out. He's not being held on the battleground matter currently. And then I know the client has some reservations about setting this matter over, so I'll just let Your Honor, we're waiting on some video evidence apparently from Walmart, and I believe that my office is in the process of obtaining that from the prosecutor. So I guess the client's real strong desire is to have reviewed that video by the next hearing to make a determination if he wants to go to trial or resolve in some other meaningful way.
All right, Mr. Wyden, so it sounds to me like we're not doing any kind of waiver today. We're setting you over to the 11th of May to facilitate some evidence being provided, video evidence. Is that your understanding?
Yes.
And are you in agreement with that?
Yep.
All right, so we'll see you back here on May 11th. If you are in custody, you'll certainly be brought over to a jail booth. If you are out of custody, please be here at 10 a.m. That is a mandatory court date. You understand, sir?
Yes.
All right, thank you. We're done with your matter. All right, Mr. Campbell.
And then, Your Honor, I have a arraignment that was from
Mr.
this
Burrows?
morning. Mr. Burrows. Come on, Mr. Burrows. Nope, Mr. Burrows. Your Honor, I believe I wasn't here, but the arraignment has already proceeded with not guilty plea. If not, we're entering a not guilty plea. And then there are some release conditions that the city is requesting, and we can provide some input on those.
Okay. So I did identify Mr. Burrows. We had not yet entered a plea, but at this time I will enter a plea of not guilty at this time, Mr. Burrows, to preserve, all your rights. We're going to be setting some return court dates, sir, and then we're going to be discussing conditions of release. We are going to assign what is called an attorney pretrial. That's a date that Mr. Campbell will be able to appear on your behalf to discuss your case with Ms. Carmy. Your next mandatory court date, sir, is going to be on the 25th of May, 2023, and that's going to be at 10 o'clock in the morning. If you fail to appear at that time, a warrant for your arrest can be issued, so please make sure to keep that document and recall that court date. In regards to release conditions, go ahead, Ms. Carmy.
Your Honor, this is Ryan Busby, conflict
Oh, sorry.
prosecutor.
Got me again. Go ahead, Mr. Busby.
City is asking for intensive pretrial release. That was already previously ordered by district court, and a formal no contact order. I believe I've provided a form to the court. I spoke with the victim in this case, and he has requested that the no contact order be entered in this case as he is concerned. I would note for the court that the defendant has a conviction for a assault 4 in 2021 that was amended down from a domestic violence charge. The allegations in this case in the PC statement are pretty significant. Could have been a very serious and much more serious assault had the victim not been able to escape. And so the behavior is exceptionally concerning, and so the city has the request for that no contact order at this time.
Mr. Campbell.
Your Honor, I know my client does have concerns in the no contact order. I've gone over the no contact order with him, and the likelihood of Your Honor entering it. The victim in this matter, I understand, may be my client's father, so I could just create some difficulties for my client associated with family events and things of that nature. He has been apprised of his responsibilities if Your Honor enters the no contact order, and I wasn't aware at the time, but it just seems inevitable that Your Honor would, based off of the victim's input. So we'll do some things pending the next court hearing to potentially mitigate and put my client in a position to be able to talk to Your Honor about the no contact order, because I know that it's something that he would like to be able to see his father, or at least speak to him in some matter. But absent victim input on that, I don't see how I can make any argument on it. And then as to the intensive supervision, I mean, he doesn't have a whole lot of family support at this time. I do have some concerns about him being put on intensive only, in that he would have to appear in person in downtown Vancouver. He says generally he can get there lawfully, but his confidence level didn't seem to me to be finite. I'd prefer him to be able to have an opportunity to do phone check-ins on the enhanced level, which I think is 1 time a month phone and 1 time a month in person, if I'm not mistaken. But I understand Your Honor's perspective on that.
Any objection to enhanced rather than intensive, Ms. Carmy?
It's Mr. Busby.
Mr. Busby. Dang.
Your Honor, no objection to enhanced at this point.
Yeah,
Just
I think
one-
I'm more compelled to do the enhanced, just because the worst situation is just someone not having transportation and not being able to make it. Although I know I think both the intensive and the enhanced, there is a probation or a pretrial release officer that comes to Battleground.
Okay.
Josh Wilson, I believe, comes out here and does.
I'm located in Vancouver.
He lives in Vancouver.
Okay.
It's just that the traveling issue is,
Okay.
problematic.
Yeah, I lived at that address.
Just a minute.
So at this point, Mr. Burrows, the following are your conditions of release. You're to violate no laws. You're to appear at all mandatory court dates. Again, the next mandatory court date, May 25th, 2023 at 10 a.m. You're to notify the court of any change of address or phone number. I am placing you on enhanced pretrial release. I have signed off on a standalone no contact order. No contact orders can be complicated. There's a lot of legal terminology. You have an attorney, Mr. Campbell. If you're unsure of what a word means or what you can or can't do, please use him as a resource. I hate to have people appearing in front of me on new charges simply because they don't understand. You are going to get a copy of this form today. Again, use your attorney as a resource. Do you understand? We're going to get you some paperwork over by the door. Once you have your paperwork, you are free to go.
Thank you, Judge. Go ahead and just stand over there. No, I have some matters that I need to speak with the clients on. You're on.
It's just fine. Is Anatoly Deravyanichuk here? All right, thank you, sir. Can I have you state your name and date of birth, please, for the record?
Anatoly Deravanchuk. And what?
Your date of birth. as well.
1370.
Okay. So I wanted to, it looks like your case was originally charged as a trip permit violation. I have documentation before me that shows that the case is being amended down from a trip permit violation to a failure to register vehicle. There's a fine of $145 and a $150 filing fee, along with a $300 public defender recoupment. Are you in agreement to this infraction today, sir? Okay, looks like it's been signed by the parties. I am fine with signing that as well. Our court clerks are going to get you some documentation over by the door that talks about paying your fine. Once you have those documents, you are free to go. Thank you.
Thank you.
Good morning, Ms. Gaffney. Was there a particular matter that you were joining us on?
Yes, Your Honor, I'm here on Corinne Davis. I was just looking for her in the participants. We're here on her stay.
Yeah, she's in the waiting room. Do you want me to bring her in?
Yes, please. Thank you, Your Honor.
Do you need to speak to her at all before the hearing?
No, I spoke with her yesterday and I just emailed Ms. Carmi the stay. We entered October 13 of 2022.
Okay, so we're connecting
you.
Ms. Davis now. Ms. Davis, can you hear the court, ma'am? You are muted, it looks like right now, Ms. Davis. Ms. Davis, if you can hear the court, ma'am, I need you to take yourself off of mute so we can have your court proceeding. Your attorney is here and ready to go. All right, I do see that you're off mute now, Ms. Davis. Can you hear the court?
Hello?
Okay, Ms. Davis, can you turn your camera on, please, ma'am?
Yes.
Thank you. Thank you, ma'am. Can you state your name and your date of birth, please, for the record?
It's Corinne, Corinne, Davis, Davis, and date of birth 11/20/95.
Thank you, Ms. Davis. Your attorney, Ms. Gaffney, is present here with us. Go ahead, Ms. Gaffney.
Your Honor, we have an agreement and I'll defer to the prosecutor. We are going to extend out the stay. This stay was entered October 13, 2022 and October 20th, 2022. Ms. Davis went into custody in Clark County on several matters that are now resolved. She then had to head over to Oregon because she's also on Oregon supervision. So we're asking the court to extend the stay 6 months because we basically lost 6 months. Ms. Davis never was able to actually begin the community service or the mental health treatment because she's been incarcerated up until April 7th, 2023. Thank you, Your Honor.
Thank you. Ms. Carmi.
Yes, Your Honor. In making this agreement to further extend the stay 6 months, it's because of the city's strong belief that the mental health treatment is what's required for Ms. Davis. We would also note that the reasons that she was being held are not because of new law violations, but rather pre-existing matters that she was then taken into custody on. So we are giving her this final chance because the city does want her to comply both with the community service component, giving her some ties to her local community, as well as our.
Two court dates at the same time.
Ms. Davis, we're handling your court matter, ma'am. We need to have you be quiet while the prosecutor's talking. Do you understand?
As well as our sincere hope that she does comply with that mental health treatment. Certainly this will be the city's last opportunity to extend the stay.
Ms. Davis, can you just stay in one location while we complete your hearing, ma'am?
I think my client may be muted. She's currently staying. She just entered Bybee Lakes Hope Center. That's the old Mr. Schnitzer, Gordon Schnitzer. That's the old facility. She's living there. So she may be in the hall, I think.
That's fine. So Ms. Davis, my understanding is that you were able to talk to Ms. Gaffney yesterday.
Corinne, you're muted.
Yes, sir. Sorry.
And do you understand moving forward what the obligations on your stay are going to be, the things that you have to do to accomplish the stay?
Yes, sir.
Okay. Ms. Gaffney, I'm certainly going to keep you on Ms. Davis's case. I think that she requires that assistance. Right now, my proposal would be to set Ms. Davis to July 13th. If that's an available date for Ms. Gaffney as her review date to check in on her community service and her other conditions. Is that agreeable to the parties?
Yes, it is.
Yes, Your Honor.
And then go ahead, Ms. Gaffney.
Just to clarify, though, the Oregon matter is an old matter, but there were new matters in Superior Court that Ms. LaValle represented her on. She was unable to enter mental health court on those felonies. So I just want to clarify that that was a new matter that I forwarded the information to Ms. Armion. Just for the record.
I do have the convictions on this.
Okay.
Thank you.
Okay, so am I doing a return to court for Ms. Davis or a probation? Let me look here.
So the city's perspective is that we would do a review order where Your Honor would indicate that the new dismissal date for the stay is April 11, 2024.
Okay, let's do that right now. What's the new date again?
April 11, 2024, which is a 6-month extension from the original termination date.
Okay. And we said that that review date for Ms. Davis will be on July 13, 2023. That's a hearing at 1:30, Ms. Davis. That is a mandatory court date. You can choose to appear over Zoom like you're appearing today. Does our court have an address for Ms. Davis, or do I'm having nodded heads? So we do. It looks like we do have an address for Ms. Davis. So we're going to mail you your court paperwork. Please stay engaged with Ms. Gaffney if you have any issues. Okay, Ms. Davis?
I will, sir. Thank you.
Thank you, ma'am. I appreciate your time. We'll talk to you soon.
Thank you, Your
Have a
Honor.
Good day. Thank you.
Thank you, Corinne. Thank you, Ms. You're welcome. Thank you, Ms. Carmi.
Thank you, Mary Kay.
Thank you, Miss Carmi. Have a
Thank-
good day.
Yes.
Okay.
All right. And that is ready to be printed and signed. I did it as a probation form. Did note the extension of the jurisdiction. I'm assuming that everybody else that's remaining in the courtroom this morning is represented by either Mr. Campbell or Ms. Engstrom. Am I correct, or is there anyone that's here on their own? All right, I don't see any hands, so we're gonna have to just wait until Ms. Engstrom or Mr. Campbell have matters ready. I will grant you 3 minutes, not a minute more. That's good. I already did that one. Stole your thunder.
I have Dustin Baker. Hey, Dustin? Okay. I'll have paperwork for you in just a second.
Sounds good. All right, Mr. Baker, if you want to come forward, please, sir. If I could, sir, just for the record, have you state your name and date of birth, please?
Dustin Lincoln Baker, 7/31/1982.
Thank you, Mr. Baker. Mr. Baker, I have a document before me that amends your criminal driving while suspended third-degree charge to an infraction called failure to display a license. There is a fine of $145, a filing fee of $150, and what is called a public defender recoupment of $300. By the signatures on here, I'm assuming you're agreeing to this reduction?
Yeah.
Okay. I'm going to go ahead and sign off on the document. We're going to get you a copy of the document, sir, over by the door. Once you have that copy, we're going to give you some information on how to get your fine paid, and then you are free to go. Thank you.
Just want to ask you a question.
Sure.
I'm redacting, a treatment report for prosecution.
Okay.
We're reviewing them today. Is it suitable for me to just provide the cover, the first page and then the treatment recommendation page, so I have to redact the entire evaluation, or do you need the entirety of the evaluation?
No, so as long as I have the diagnoses of alcohol dependence,
Yeah.
and then I have documentation showing the 3 phases of treatment over a 2-year period, that would be the only thing I need to find statutorily to enter your client into deferred prosecution.
That's why I had so the evaluation, and this is from a local provider that should know how to provide these reports. It's not my client's issue, but the evaluation recommendation is as follows. Individual reports the UI is opting for deferred prosecution, and then it shows the overall level of care of 2.1, which is the initial phase deferred, but it doesn't outline the entire treatment plan from start to finish deferred, if that makes sense.
Guys.
And so I can have the client, I can reach out and speak to the provider about that. I mean, I think that I've had a concern with the prosecution about that. I mean, it's not the client's mistake.
So by statute, even though that word is in there, I need something that shows that the treatment duration is going to be 2 years. I also need to see at the minimum phase 1 of 72 hours of IOP, phase 2, 26 weeks of aftercare, and phase 3, 18 months of monthly monitoring. If that's not spelled out contractually, because it's technically a contract, I don't think we can enter your deferred today. Okay. Okay, thank you. Ms. Engstrom, did you have a matter you wanted to call?
Yes, Your Honor, we have Mr. Harvey.
Okay, Mr. Hartley, if you'd come forward, please, with your attorney. And Mr. Hartley, good morning. If I could have you state your name and date of birth, please, for the record.
Michael Hartley, 110289.
Mr. Hartley, by the paperwork I have been handed, it looks like you are entering a plea today. Is that your understanding?
Yes, Your Honor.
Have you had plenty of time to review the plea with Ms. Ingstrom?
Yes, Your Honor.
Any additional time to talk to her before we proceed today?
No, Your Honor.
Shows that you are 33 years old. You have your GED. Is that correct?
Yes.
Are you able to read and understand the English language?
Yes.
The charge which you are pleading to, operating a motor vehicle without an ignition interlock device, is what is called a gross misdemeanor in the state of Washington, meaning it's subject to 364 days in jail and a $5,000 fine. You're giving up several important rights that I'm going to review with you this morning to make sure you understand. You have the right on the case to have a speedy and public trial and by an impartial jury in the county where the crime is alleged to have been committed. You have the right to remain silent before and during trial and the right to refuse to testify against yourself. You have the right at trial to hear and question the witnesses who testify against you, the right at trial to testify and have witnesses testify for you, and the witnesses can be made to appear at no expense to you. You're presumed innocent unless the charge is proven beyond a reasonable doubt or you enter a plea of guilty. And you have the right to appeal a finding of guilt after trial. You understand those rights?
Yes, Your Honor.
And you understand that in your plea today, you're waiving or giving up those rights.
Yes.
We talked about the maximum duration for the charge. You understand that while there is a pretrial agreement, the court does not have to follow anyone's recommendation as to sentence, but can sentence you up to the maximum authorized by law.
Yes, Your Honor.
Court can place you on probation for a time frame of 2 years, during which time you can pay cost, fees, and assessments as authorized by law.
Yes.
And if you're not a U.S. citizen, a plea can result in immigration or deportation issues. So box J is checked on the plea form. It's not applicable. It's the 30-day suspension box.
No.
He's not subject to a license suspension.
Okay.
What he is subject to, though, is the extension of the interlock requirement. And that is that is box T, but that is checked. So we're covered on that. What I'm being clear about, sir, is that this does not involve a new license suspension. It does extend the jurisdiction for interlock by the Department of Licensing by 6 additional months. So one thing that you thought was going to happen is not going to happen. The other thing is still going forward. My question to you is, are you still looking to enter your plea today based on this information?
Yes, Your
I
Honor.
just want to make sure. Okay. Have notated the box T has been checked. So the charge of operating a vehicle without an ignition interlock device taking place on March 12th, 2023 in Richfield, Washington. How do you plead?
Guilty, Your Honor.
Are you making this plea freely and voluntarily?
Yes.
Has anyone made any threats or promises to get you to plead guilty?
No.
The factual basis states on or about March 12th, 2023 in Richfield, Washington, you operated a motor vehicle that was required to be equipped with a functioning ignition interlock device and was not so equipped. Is that a correct statement?
Yes, Your Honor.
Okay. I will accept the plea, find it knowing, intelligent, and voluntarily made after advice of rights and advice of counsel. What's going to happen now, Mr. Hartley, is I'm going to hear from the city attorney, Ms. Carmi. I'm then going to hear from your attorney, Ms. Ingstrom. And if you choose to address the court, you certainly can as well before I pronounce sentence. Go ahead, Ms. Carmi.
Yes, Your Honor, we would ask this court to follow the pretrial recommendations. It was negotiated. And I hope that it's specifically noted, but if not, we would ask the court to note that because of this plea to the ignition interlock, the city is dismissing count 2, driving with suspended license, 3rd-degree charge.
And we'll note that dismissal. I'm going to dismiss on the face of the citation. Count 2. Go ahead, Ms. Ingstrom.
Your Honor, we would just ask that you follow the negotiated plea on this one. Mr. Hartley had been doing some work on his girlfriend's car to get a little test drive, and that was a massive mistake on his part. But I hope not to see him back.
Mr. Hartley, is there anything that you would like the court to know before the plea? Or before, excuse me, sentencing?
No, Your Honor.
I will follow the recommendation of the parties. I did again dismiss count 2 pursuant to plea. That was an original charge of driving while suspended in the 3rd degree. That case has been dismissed. Count 1, the interlock violation, 364 days with 354 days suspended, 10 days to serve. Those 10 days are going to be done on the work crew program. As I tell every single person who appears in front of me, you must do at least 1 day of work crew every 30 days. If more than 30, you can do more. If more than 30 days pass and you haven't done work crew, it gets returned to me, can be converted to jail time. So please make sure you're diligent about your work crew. You can sign up with the work crew chief here, or we can give you his contact information as well. It's a $5,000 fine with 4,900 suspended for a $100 fine to pay. There is a public defender recoupment, a traffic penalty assessment, and a conviction fee that's been added along with the work crew fee. Total fine of $725.50. You can do a payment plan on that fine through the court. Conditions of sentence: no criminal violations, not to drive without a valid license. You are on bench probation for 24 months. We're going to set a return date, sir, for the 13th of July, 2023. At that point, we'll be reviewing your progress on work crew. My hope is in that 3 months, you can almost have your work crew done by the time you come back for court. Okay. Certainly, if you finish early, I get to cancel the hearing. You don't have to come see me again. So that might be even more reason to work hard on that work crew. Mr. Hartley, do you have any questions at all about the sentence the court has imposed today?
No, Your Honor.
We're going to get you copies of all your paperwork over by the door. I don't know if Devin, our work crew chief, is here right now. I'm getting a nod that he is. So you can go to the same place you checked in for court where the plexiglass is and ask for Devin. And Devin can go ahead and get you some sign up information to get the work crew started. Okay. Thank you, sir. Good luck. Thank you.
All right, you have to celebrate that as the call.
Sounds good.
Mr. Johnson being the first one.
Okay. Mark Johnson, come forward, please. And Mr. Johnson, if I could have you state your name and date of birth, please, for the record.
Mark Johnson, 12/25/62.
Thank you, Mr. Johnson. Go ahead, Mr. Campbell.
And Your Honor, this matter is actually currently on for trial in May. The prosecutor and I have been working through some things, and actually what defense is asking for at this time, and I believe it's supported by the city, is to strike our current trial setting and set this matter over for a review hearing on May 25th. And the reason being is I've involved some investigation with the post office and certain relative to some certain pretrial motions in one case. As well, I've gotten some documentation together associated with a family law case that I think at a minimum mitigates some certain aspects of the second case. And so I believe that at this point, it's prudent and in the administrative, in fairness to the administration of justice in this case, to intervene and remove that current trial setting. If we're not able to come to a meeting of the minds on certain things, we have some contested motions that I believe would be potentially dispositive of these various charges. And so I think what we would be doing is scheduling contested motions at that May hearing and then scheduling trial after the contested motions were heard if we're not able to intervene in an earlier way in this case. And so I believe that the city and the defense are in support of that posture of this matter at this time.
That is correct, Your Honor.
Mr. Johnson, have you been able to discuss with your attorney, Mr. Campbell, your right to a speedy trial?
Yes, Your Honor.
And it sounds to me like you're agreeing to waive that right beginning or commencing May 25th, 2023. That would give the city of Battleground 90 days from that date if it became necessary to bring you to trial. Okay. So based on that waiver, we are going to strike the trial that was previously scheduled for May 16, 2023. That is no longer a required court date for you, Mr. Johnson. Mr. Johnson's next mandatory court date will be May 25th, 2023 at 10 o'clock in the morning. It sounds like there's developments happening on your case, Mr. Johnson, so please make sure you're staying in good contact with Mr. Campbell so you're up to speed on exactly what's going to take place at that next court date. We're going to get you some documents over by the door, sir. Once you have your paperwork, you are free to go. Thank you, sir.
And then next, Your Honor, we have Isaac Reynolds. Okay. We're really hopeful to enter this case into a deferred. There are some issues with the paperwork that we already discussed. This was that matter that I was questioning Your Honor about. So I'm going to need to reach out to the treating provider and get a letter outlining the steps explicitly associated with the deferred. My client's successfully engaged in treatment currently, which is a good thing. And so hopefully by that next court date of May 11th, if Your Honor accepts the waiver and sets it over, then we should be ready to enter the deferred at that point.
Yeah, unfortunately, Mr. Reynolds, the legislature is very clear about the guidelines for deferred prosecution, and the court has to make a finding that your evaluation and treatment plan comply. Mr. Campbell's right. It says deferred prosecution on it. We all know what that means, but I have to specifically see the treatment plan that you're going to be undertaking, and that has to be on file with the court. So, so we will set this matter over. Do you understand your right to a speedy trial, Mr. Reynolds?
Yes, sir.
You understand that in doing a commencement date of May 11th, you're giving the city of Battleground 90 days from that date if it becomes necessary to bring you to trial. Are you in agreement with that? We'll accept the waiver, find it knowing, intelligent, and voluntarily made. Mr. Reynolds' next mandatory court date is May 11th, 2023. At 10 o'clock in the morning, release conditions will remain in place. It sounds to me like we probably are one piece of paper away, Mr. Reynolds, to get this thing put to bed. So we'll get that last document and get this thing resolved. Okay. Thank you, sir. We'll get you some paperwork by the door. Once you have it, you're free to go. Thank you.
And then, Your Honor, you're good. I'm waiting on some treatment records for another matter. I may set a couple matters over the afternoon. There's a possibility I may have an ability to resolve one or two this morning. Still, I just need to speak with the clients. I appreciate it.
And I do have, just wanted to point out, I have Ms. Sue that's with us on Zoom. She is yours, it looks like.
Okay, well, I'll need a breakout then, I think with that.
And then I have Ms. Tatum, who I believe is with Ms. Engstrom back in our waiting room, so I'll try to bring her in again. I am bringing in Ms. Tatum. I think she is yours, Ms. Engstrom. She was connected earlier. She disconnected. I don't know if she's having connection. Oh, she's connected audio. Ms. Tatum, can you hear the court, ma'am?
Yes, I can.
Wonderful. Thank you. Okay, I do see you. Ms. Tatum, can you state your name and date of birth, please, for the record? So Ms. Tatum, you can go ahead and turn your camera off because it sounds like we're having some connection issues. If you can hear this, we might be able to get better.
Dreama Tatum, 52684.
Wonderful. Thank you, Ms. Tatum. Your attorney, Ms. Engstrom, is present with us here in court. Go ahead, Ms. Engstrom.
Your Honor, there's some peripheral issues that I still need to deal with on this one, and I was going to request a roughly 30 days set over to May 18th if possible.
Okay. I'm just going to take a quick look about where we are on speedy.
I just looked, Your Honor, it commenced just about 2 weeks ago on March 30th. So I am in agreement to a mid-May set over without a new waiver.
Okay. So Ms. Tatum, it sounds like Ms. Engstrom just has a few more matters to get attended to, and that she's asking that you be able to return on May 18th, I believe is what you said.
Yes.
Are you in agreement with that, Ms. Tatum?
Yes, that is fine. I also
Okay.
have an address now.
Okay, I'm gonna get that from you here in just a minute. I'm gonna just get your paperwork filled in, then we'll get that new address, okay?
Okay.
So Ms. Tatum, that next court date, which we call a readiness hearing, that's gonna be at 10 o'clock in the morning on May 18th, 2023. That is a mandatory court date. Any release conditions, including the no contact with Walmart, is gonna remain in place along with the administrative release. You did state that you had a new address. Do you want to go ahead and provide that address right now?
Yeah, it's physical address. I haven't switched my mail over yet, but I think because of pre-release would want one.
So I know that the previous address was for general delivery. Do you want us to still mail it to general delivery, or do you want to give us a different mailing address?
I still want it to go mail to go to general delivery, but my physical address
Okay,
is gonna be 1306 9th Avenue. Number 18, Washington.
have you been able to be in contact with her, Ms. Ingstrom?
Yes.
Okay. All right, Ms. Tatum, we're going to see you back here on May 18th. We will use that same address for mailing. Please make sure you're staying in touch with Ms. Ingstrom, okay?
All right, well, thank you very much. Have a good day.
Thank you, Ms. Tatum. You go ahead and log out. Thank you, ma'am.
I have Bethel and Brian on.
Mr. Busby is with us. Mr. Busby, are we ready to call the Cody Fessel matter?
Yes.
All right, go ahead, Ms. Ingstrom.
Your Honor, and I was going to request a set over on this one as well. I just haven't been able to effectively.
Is he present?
Mr. Bethel,
Is Cody Fessel here?
is he on the phone?
No, the only person who was on Zoom was Ms. Sue, and I have her in.
He's been texting me and trying to call me all morning, so I wonder if he's having some.
Okay, sounds good.
He was the message I was waiting to get to you. Mr. Festival was attempting to get on Zoom and not, was gonna reach out to you.
Okay.
Right.
Yeah, he was trying to get a hold of me, I know, and I was dealing with some other stuff.
Okay, sounds good. Well, I guess Mr. Busby will recall Mr. Fessel when we figure that out.
All right. Thank you, Your Honor.
Yep.
You call him, he's having Zoom issues.
You give me a phone number, I can call him.
Okay. I have his phone number.
You want to try that right now?
Yeah, we may as well.
Okay. Go ahead when you're ready.
This is my, tech savvy right here. I'm for minutes, Cody, and now I can't see his number.
Usually if you hit the info thing on the top, like where the name is, it'll show all their info.
Number said it doesn't work like a normal.
No, it's not a problem. We can, when you're ready, just let me know. Or just hand it up on a post-it note or something and I'll call. Okay. Just gonna get a sense of who's waiting in the courtroom right now. Is Kylie Bernard here? I've seen Mr. Brown. Mr. Fessel's on the phone. Levi Grass. Okay, Mr. Grass is here. Logan Hall. Yeah, outside. Okay, got it. Aaliyah Lawson. Is Lawson's here? Veronica Lopez.
No, it's mine, Your Honor. She was, and we're working through some documents.
Okay, got it. Charles Ray. Cheryl Sue is with us on Zoom. Jesse Thompson. Might be out with Mr. Campbell and Brittany Whitick. All right, let's call Mr. Fessel. Got it. Thank you.
Hello?
Hi, is this Mr. Fessel?
Yes.
Hi, Mr. Fessel. This is Judge Andrew Wheeler calling from the Battleground Municipal Court. My understanding was you were having a hard time joining us today on Zoom.
Yes, I went to the link and copied it, like exactly like it was, the http://Zoom, and went to it, and it wasn't allowing me to join a meeting or log in and do my ID. It was saying unable to access this app or something. And then it was saying I had to download it, and it won't let me download it.
So the sense is probably for future court dates, if you're having those kind of tech issues, we are here in person, so you can choose to show up here instead, okay?
Yes, I was trying to do that. I've been working, I just started back to work, let alone 12-hour shift, 2:30 in that afternoon to 2:30 AM at night, and getting up early and stuff. It's difficult, but the difficult part is the ride and everything, because 90.
Okay, that's fine. We do have your attorney, Ms. Engstrom. I'm fine with you appearing on the phone today. We also have the prosecutor, Mr. Busby, present. Ms. Engstrom, how is Mr. Fessel asking to proceed at this time?
We are just asking for a set over on this. I just haven't, he is in contact, but I haven't had time to effectively go over everything with him.
How far out were you asking to schedule this?
I did not see when speedy trial was, but if we could just keep it with May 18th with the other one, I'm here.
Yeah, so it looks like Mr. Fessel, I believe, was arraigned on the 2nd of March. So May 18th would put us a little over 60 days. Ms. Carmi, to set to that date for Mr. Fessel, do you want a waiver or are you comfortable setting to that date?
Your Honor, this is
I'm sorry.
Prosecutor Ryan Busby. The city would request a waiver to put it out that far.
Okay. Ms. Engstrom, have you discussed with Mr. Fessel his right to a speedy trial?
I believe I did. We can also set it, I'm here again in 2 weeks, I believe on the 27th.
So Mr. Fessel, normally from the first time you went to court, you'd have to be brought to trial within 90 days. Right now, because you're about 75 days into your speedy trial, if we set to May, the two options are not to waive your right to speedy trial and see you back here in 2 weeks, or to do a waiver and have you come back on the 18th of May. Either one is completely fine, but one of them would require you to do a waiver of your right to speedy trial. You wouldn't be giving up your right to go to trial. Simply, it would set a new 90 days. So would you prefer to do a waiver and come back in May, or to come back just in 2 weeks?
I'll do a waiver and come back in May. That'll give me time to figure out and try to get my license back too.
Okay. So Mr. Fessel, you and I talked about it a little bit on our call. Do you have any questions, sir, about your right to a speedy trial?
No, sir.
And if we are doing what's called a commencement date, we would begin that speedy trial again on the 18th of May. Is that acceptable to you?
Yes, sir.
Do you have any questions at all about doing that?
No.
Okay. I am going to find that Mr. Fessel is making a knowing, intelligent, and voluntary waiver. I am finding that the commencement date shall be the return date, which is May 18th, 2023. And that hearing, sir, is going to take place on that day at 10 o'clock in the morning. That is a mandatory court date. So again, you either want to make sure you have that Zoom issue really ironed out, or we have a ride in place to get you down here, okay?
Okay. And you said May 18th?
May 18th, 2023 at 10 o'clock in the morning. We are going to send you out notice about this. Are you still getting your mail at the address on 157th Court?
Yes, 8510.
Yep, we'll send the paperwork there.
Yes, and I've seen, my number was on there wrong. I think they have it 773 and it's 713.
When you say your number, do you mean the phone number?
Yes, the phone number.
Okay. Got it. All right, so we'll mail you out the documentation, Mr. Fessel. We'll see you back here on May 18th at 10 o'clock in the morning. Do you have any questions at all, sir?
No, sir.
Okay, we will see you then. Thank you. Have a good day.
You too.
All right, take care. Bye.
Thank you.
Yep. I have his phone number if it's helpful, Carol.
I think we have it 360-713-1643.
I think the end of it is, yeah, 1643. That's correct.
Open place.
I am in an open place, just in a good place mentally, ready to go.
Levi Graff, Your Honor.
Okay.
Pro se, please.
All right, Mr. Grass, if you want to come forward, please, sir. I did see that you had the opportunity, and we're talking to Ms. Carmi this morning about your case.
Yes.
Need any additional time to speak to her before you appear in front of me?
No.
Okay. You are Levi Grass, you're 37 and you have your GED, is that correct?
Yes.
And you're able to read and understand the English language?
Okay.
By the paperwork on file today, sir, it looks like you're entering a plea to a charge called driving while suspended in the 3rd degree. And entering your plea today, you're giving up some important rights that I'm going to review with you here on the record. You have the right to a speedy and public trial by an impartial jury in the county where the crimes alleged to have been committed. You have the right to remain silent before enduring trial and the right to refuse to testify against yourself. You have the right at trial to hear and question the witnesses who testify against you. You have the right at trial to testify and have witnesses testify for you, and these witnesses can be made to appear at no expense to you. You're presumed innocent unless the charge is proven beyond a reasonable doubt or you enter a plea of guilty. And you have the right to appeal a finding of guilt after trial. You understand those rights?
Yes, sir.
And you understand that in entering your plea today, you're waiving or giving up those rights.
Yes.
Okay. We did talk about that the charge was called a simple misdemeanor subject to 90 days in jail and a $1,000 fine. There is a pretrial agreement that the city has handed forward. You understand the court does not have to follow anyone's recommendation as to sentence, but can sentence you up to the maximum authorized by law.
Sir.
Okay. Court can place you on a term of probation for 2 years, during which time you pay cost, fees, and assessments as authorized by law. And if you're not a U.S. citizen, a plea can result in immigration or deportation issues. To the charge of driving while suspended in the 3rd degree, taking place on February 24th, 2023 in the city of Richfield, Washington. How do you plead? Are you making this plea freely and voluntarily, sir? Has anyone made any threats or promises to get you to plead guilty? And just because we are recording this as well, you shook your head no.
Yeah, no.
Okay, just wanted to make sure. The factual basis, sir, states that on or about February 24th, 2023 in the city of Richfield, Washington, I did operate a motor vehicle while knowing my driver's license was suspended in the third degree. Is that a correct statement?
Yes.
Is this your signature on the line where it says defendant?
Yes, sir.
Okay. I will accept the plea. I'll find it knowing, intelligent, and voluntarily made after advice of rights, consultation with the city attorney. What's going to happen now, Mr. Grass, is I'm going to hear briefly from the city attorney, Ms. Carmy. You also have the right to address the court before I sentence. Go ahead, Ms. Carmy.
Yes, Your Honor. Mr. Grass has been in communication with my office via email on several occasions. We had emailed him this paperwork recently when he indicated to us that he wanted to go ahead and enter the plea. So we do think that it's knowing and voluntary. He's had ample time to review it. We reconfirmed that this morning before he signed the documents. And we had him initial the appendix sheet so that he's aware of what the elements would be if we were to take this case to trial. So we feel like this is a resolution that we would ask the court to follow.
Do you have a judgment and sentence page filled out, Ms. Carmy? Am I
Nope.
just missing it here?
Nope, I don't have it. Hold on 1 second. The
Okay.
J and S. Hold on. Maybe I do have it here.
Mr. Grass, one of my astute court clerks handed me what is called a waiver of right to an attorney. Probably should have done this before the plea, but I'm going to do it now. And if you decide you want to have an attorney, I will revoke the plea. But the waiver of right to attorney reads that you understand you're charged with the crime of driving while suspended in the third degree.
Yep.
As it states in your citation. You understand the maximum and minimum penalties. That's in the appendix that you initialed.
Yes, sir.
There are not any minimum penalties. That's number 3. Number 4 states you have the right to an attorney to represent you at all stages of the proceeding. You cannot afford an attorney. You have the right to request a public defender. If you qualify, an attorney will be appointed to represent you. Number 5 says I may be at a disadvantage if I proceed without an attorney. I'll be required to follow the laws and court rules which apply to the case. These laws and rules can be technical and complex. I may not fully understand them without an attorney. Number 6 says I'm aware of the dangers and disadvantages of proceeding without an attorney. However, I choose to represent myself knowing the risks. I waive my right to be represented by an attorney. The court has had a colloquy with me on my rights to an attorney and my desire to waive this right. No one has made any threats or promises to get me to waive this right. I'm doing it of my own free will. Do you have any questions regarding the waiver, sir?
No, sir.
Okay. I'm going to go ahead and sign off on the waiver. At this point, are you still okay with having proceeded in this matter pro se on your own?
Yes, sir.
Okay. I'm going to ask you to come forward because unfortunately they keep all the pens up here with me. And you're going to print, sign your name and write the date. And I have a pen here that you could do that with. There you go. There's a print the name option right there to right in there. Yeah. And I'll add the date in for you if you're okay with that. There you go. Thank you. Okay.
Here you go, Your Honor. And we made a notation that part of this plea is dismissal of the traffic infraction.
Okay. I will do that on the face of the citate of the infraction. All right. Slightly out of order, but back in business, Mr. Grass. We'll go forward with the plea now. Or with the sentencing. It looks like I am going to be dismissing the associated traffic infraction. So let me do that before we go to the next step. This is a failure to renew or having expired registration by 2 months, 3A0164-243. Pursuant to plea, that matter is being dismissed. On cause number 3A0164-242, driving while suspended in the third degree, and will follow the recommendation of the parties. 90 days with 88 days suspended, 2 days to serve on work crew. As you heard me tell the other folks that have been pleading today, please make sure you do at least 1 day of work crew every 30 days. You can absolutely choose to do more.
You say there's contact information for the person in charge of that?
Yeah, so he actually is here right now. So if you go to the same place that you checked in where the plexiglass is, just ask for Devin. He's the work crew chief.
Okay.
Yeah, just right around the corner.
All right.
$1,000 fine with 900 suspended for $100 fine to pay. To which is added a $30 work crew fee, a conviction fee, a traffic penalty assessment, and a filing fee. Let me just do the math here real quick. So a total financial obligation of $425.50. We'll give you some information on how to get that paid. Bench probation for 24 months. We're going to set a return date for the 13th of July. The easiest way to cancel that return court date is to complete those 2 days of work crew, because that's the only thing I'm monitoring you on, other than making sure that you are remaining law abiding. Okay. So, Mr. Grass, we're going to be getting you some documents over by the door. Once you have your paperwork, you are free to go.
Appreciate it.
Make sure to check in with the work crew chief.
I will.
All right. Thank you, sir. Thank you. The gentleman who just came in, are one of you here for court?
Yes, Charles Ray.
Mr. Ray? Okay, great. Mr. Campbell's here. He'll call you here hopefully soon. Yep.
Okay, Judge. See here, we have Mr. Thompson.
Morning, sir. If I could have you state your name and date of birth, please, for the record.
Jesse Thompson, 4/17/1973.
Thank you, sir.
So Judge, I'm sorry,
ahead.
we're just asking for a continuance. This is, I mean, I really have to apologize to my client. It's really no fault of his own. This matter's been ready to resolve. There's been some issues with an insurance company asking for restitution. I think we've worked through that with prosecutor, and then for reasons that I won't go into on the record, that there has been a little bit of difficulty in the prosecution's office in obtaining victim consent to our agreement, or at least notifying them of our agreement. And so, and that was really no fault of the prosecutors either. So I thought we'd have this resolved. I know my client really wants to have this resolved and stop coming here, but we're asking for a very brief set over in order to be able to affect that.
Mr. Thompson, have you been able to talk to Mr. Campbell about your right to a speedy trial?
Yes, sir.
And you understand that in doing a waiver beginning April 27th, you're simply giving the city of Battle Ground 90 days from that date if it became necessary to bring you to trial. Are you in agreement with that?
Yes.
We'll accept the waiver, find it knowing, intelligently, and voluntarily made. Mr. Thompson's next court date is April 27th, 2023 at 2 p.m. It is a mandatory court date, Mr. Thompson. If you fail to appear at that time, a warrant for your arrest could be issued. We will get you some documents with your return court date. Once you have those documents, make sure you're staying in touch with Mr. Campbell, and you are free to go. Thank you.
Yep, sorry about that. Then we have an entry of a stay on Brittany Whittick's matter, Your Honor.
Okay, Ms. Whittick, if you want to come forward, please. Ms. Whittick, if I could have you state your name and date of birth, please, for the record. Whiting. I almost thought it was that.
Oh, my gosh.
And I've done it right before too.
That's totally my fault.
Oh, tricky. Okay, Ms. Whiting. You better than that. So Ms. Whiting, you're entering a stay today. A stay is a contract in this circumstance between yourself and the city of Battle Ground. I am not a party to it, meaning I don't say yes or no. I'm simply the referee. I'm going to make sure you understand the things that you have to do. And at the end of the process, I'm going to make sure the city does what they're supposed to do, which is dismiss your case. Okay. All right. This is a 12-month stay of proceedings, during which time you're going to have some fees and costs of $150 filing fee recoupment, $150 supervision fee, and a $300 public defender recoupment. Total fee of $600. You're going to be on a payment plan for those fees. Just make sure you're staying current with your payment plan. It looks like there's also restitution to Walmart that is to be paid within the next year of $154.94. That has to get paid before your stay ends. Okay. You were to do 2 days on work crew. As you heard me tell every single person, do at least 1 day of work crew every 30 days. You can always do more. Okay. No contact with Walmart, no new charges, appear at all court dates. It's like you're entering on 2 counts of theft in the 3rd degree. On both those counts, you're giving up some very important rights, including your right to go to trial. Do you understand that trial right?
Yes.
You're saying you're giving up that right?
Yes.
And are these your initials on that portion right there?
Yes.
Okay. You're also giving up your right to a speedy trial. Do you understand what your right to a speedy trial is? And you understand that in doing a waiver starting April 13th, 2024, you're giving the city of Battle Ground 90 days from that date if it became necessary to bring you to trial. Are you in agreement with that?
Yeah.
All right. And are those your initials right there? All right. We talked about that the charges are gross misdemeanors. Looks like you signed the last page right there, Ms. Whiting. Perfect. Do you have any questions of myself or of your attorney, Mr. Campbell, before I sign this document and put you in the program?
Yep.
All right, we're gonna be signing off on both your cases, entering the stay. I'm gonna see you back here on July 13th. At that time, I'm gonna check in on those 2 days of work crew. It will not break my heart if you have done 2 days of work crew and we get to cancel that court date.
Okay.
So Devin's here today, as you heard me told the other folks, check in with him on work crew right now, and we'll get that started, okay? Ms. Whiting, good luck. We'll get you some paperwork by the door. Once you have your papers, you're free to go.
Thank you.
Thank you, ma'am. Have a good day.
Okay, I'm sorry, Judge. I have a review matter that I think we can probably take, and it's Semshia, my client that's on for this afternoon, and I notify her not to be here if you'd like.
Right.
It's Addison Allen.
Okay.
So the last document that I have on this, and I hope I'm not wrong and that we can proceed and finalize this case today. indicates that she had completed her anger treatment and she had completed the NTSI, and then it says 0 of 10 work through. And
No,
then,
and she has 7 of the 10 days done is my recollection.
so this morning, Mr. Scroggins just confirmed to me orally that she's completed.
Oh,
And so, or at least he told me, Addison wanted me to tell you that she completed. So I took that to mean that she actually had.
okay.
So we can maybe get Mr. Scroggins to do an update on that, because it could have been that she has finalized some time since the last time he.
Yeah, my work crew sheet here now shows she had 1 day remaining, but as an officer of the court, I'm fine with.
Okay, perfect.
She showed today.
That's right. That's my understanding, is that she completed it today.
All right, let me just back this out. All right. I'm not going to assign any future court dates, Madam Clerk. I just saved the Addison Allen for printing.
And it looks like today is the dismissal date of the stay.
And I'm happy to check the box that also says dismissal.
Perfect.
As soon as it gets back to me.
Go ahead and sign that right there. That's waiving to May 11th, which is going to be your next day. Okay. You got plenty of time to do that, so. And then we're going to call the Charles Ray matter, Judge.
Okay, sounds good.
This is a matter that's been tracking towards a deferred. My client's been out for a long time on pretrial supervision with the scram bracelet on and not having any problems. So I think that's a really good notable thing for him. And so right now he's had some difficulty in obtaining the driver's abstract and completing his evaluation. I guess he needs some more time to do that. So we're asking Your Honor to set this over to May 11th for him to do that.
Okay.
And Your Honor, this is a case with Mr. A. I apologize. I just wanted to make sure the record was clear that what we had presented defense attorney with it's okay, the draft. We do have concerns right now about his compliance with conditions of release. It looks like he was terminated from Scram for non-payment.
Non-payment, and that's correct. And I so apologize.
No,
for
no, you're good.
presentation. I got that document this morning and it just slipped my mind, Your Honor. So are you? Gonna be able to do that on Scram? We're not having that.
So I was hoping to be able to get the deferred, I'm guessing.
Okay, just a minute, just a minute. So his financial circumstance is a little bit dire. Maybe, do you want to cite this on for a shorter time period? He indicates he's going to be able to get the evaluation completed. And I understand that we're not procedurally ready for a pretrial release violation today, but maybe because I haven't provided notice of that today, you could presumably set this on to the 27th of April instead. It's a shorter period of time if he's financially unable to obtain Scram. I don't want to set it out so far that I feel like I'm making a detriment for Your Honor or the community. So should be prepared to enter the deferred on the 27th.
I think the city's only concern is just we had implemented Scram and now we'll be spending 2 weeks without any sort of alcohol monitoring.
How long ago was he terminated from the Scram?
Just recent. Let me pull that document.
And I could go get it. The form is back at my desk, Judge.
That's fine.
I'll get there in just a second.
Fine. Indicating Monday.
Yeah, I believe we received notice Tuesday or Wednesday. So it's very recent and it was due to non-payment. It was not an alcohol violation.
So why don't we do this? We can transition him. I certainly, if he doesn't have the money for Scram, I'm not going to transition him to BART because I'm assuming we don't have money for BART. The only other option I have, I think statutorily, you can't do. I'm assuming you can't afford an interlock device.
All he would be able to provide, because he doesn't have current, he's been getting rides to court. He'd have to file a declaration of non-driving.
Can you do random UAs?
Historically, they were $30 every time it was called. That would be preferable because they may not even be called in the next 2 weeks, but I'm not sure financially how, so the way that his circumstances are currently.
I need some sort of assurance, Mr. Campbell, to cut to the chase that he's not drinking when he's not on any release condition. Statutorily, I only have 2 sort of colors I can paint with. And right now you're telling me I can't paint with either of the colors. I have enough community safety concerns and I'm not just going to untether him for the next 15, 16, 17 days So our options right now are really only random UAs. I want him at least to be calling the Keller line every day. As Keller comes up and we find that he has been drinking, then I want to at least have that mechanism to bring him back in.
Understood, Your Honor.
So we're going to transition at this point. Administrative pretrial release is still going to take place. I'm going to leave Scram on there because technically that's what I have to do. I'm going to add random UAs in. I'm going to understand that he's not going to be able to comply with Scram, at least from what I have. But like I said, I don't have any other option under statute. The last DUI, I mean, there's a DUI after this one. That was dismissed.
It's in a deferral status still. So I believe that, so it was after ours, but filed first because ours was a blood draw.
So if he's on deferred prosecution on that one, he can't do deferred prosecution on this one.
You can't, is that,
It's a, I'll tell you,
may have been a change in circumstance since the last time the client and I discussed.
I just looked at this. It is. So it's not a formal deferred prosecution. It's a 24-month agreed stipulation to a continuance, charges to be amended if defendant is compliant.
I'm not sure, Your Honor. I'll have to look into that further. I don't know statutorily if that's
I'm
that's
just
problematic. I was not aware of that resolution. Is that up in Callis?
No, that's in Clark.
Clark? I've never heard of something like that.
Oh, I'm sorry. No, Cowlitz District. I apologize.
I'll need to look at that further, Judge. I haven't.
And it looks like there's a warrant on that case as well.
He just got a warrant. That's the one I was telling you about just yesterday. Received a warrant on that case.
I mean, it's a complicated logistical circumstance that we're in, Judge.
Could we also request, Your Honor, the declaration of non-driving? If right now we're moving to random UAs with knowing that Scram is not gonna be implemented. I mean, if he's telling us he's not driving.
I was flying an airplane right now. The indicator lights would be
Yeah.
flashing, warning,
Yeah,
pull up, whatever.
yeah.
Just don't speak. And the reason being is that if you up a warrant, then you could have potentially another charge for bail jumping on that guard.
So, yes, we will do an interlock declaration. Do we have that form that I can
We-
review with him on the record?
We do here.
And we will continue on administrative release and we will add random UAs. What that means, Mr. Ray, is you need to check in with your pretrial release officer in Clark County today to get started on the color line today, okay? Right.
This is a Ridgefield case, Judge.
This is a Richfield case, yes.
So I understand that we're probably allowing here, there's control resource, I'm just having ignition on device, so we will notify people, I understand what we're doing, drive motor vehicle without ignition on device, I will not drive a motor vehicle without ignition on device. Not legally authorized to drive a motor device to revive the perjury on the law, the statement is true. Not an access to temporary motor vehicle.
I'm seeing that more and more up north is, do they not do that in Clark?
You're signing this form.
It's like an agreed stipulation with facts and like if they
The
don't.
only jurisdiction who does that,
Yeah.
they call it like a slow neg or a wet reckless, is like Skamania
Oh,
does them from time to time.
yeah.
That is WDP, that's Woodland.
Oh.
And so it's the municipal court up there.
Oh,
And so
right.
I don't know if it's the same municipal court attorney up there. I see a guy named Fred Johnson, I think, was the one who used to handle that contract. I don't know if that's still the case. So that's a Woodland Municipal, not a Cowlitz
Got it.
per se. Okay.
Yeah.
So Mr. Ray, you understand that you are not eligible to operate any vehicle of any kind that's not equipped with an interlock device?
Yes, John.
Okay. You're also going to check in with pretrial release today to get started on the random UAs. We're going to see you back here April 27th, 2023 at 10 a.m. That is a mandatory court date. I'm not entering a new waiver because his last waiver was only 2 weeks ago.
Yes, Your Honor.
We're gonna need some paperwork, Mr. Ray, over by the door. Once you have your paperwork, you are free to go.
Okay, thank you.
Thank you.
And then, Your Honor, if we could call the, go ahead and stand there. We could call the Logan Holland matter.
Okay.
And I apologize, Your Honor. This is a matter that was on at 10 a.m. I just received the evaluation recommending deferred on this matter and still need to go through that with my client. So I'm just asking that he come back at 1:30. I've spoken with him about that. And I don't,
You have the court file, I apologize.
I hope not. Don't believe so.
This is Mr. Holland.
Holland.
Okay, I misheard. Yeah, that's fine. 1:30 is fine. If you need to go over paperwork with
So
him.
just stay here, don't leave. I'm gonna go over the paperwork that we right after this. Mr. Brown is entering a plea and a stay today, and just with the way things have happened today, our negotiations were kind of unfolding. We got the agreement today, and I'm gonna need some more time for him too, so I'm gonna have to ask him, are you able to come back at 1:30? And then you and I are gonna go over the paperwork right now. So you probably wouldn't say late. Okay, so if Your Honor is amenable to that, then I'd ask that this come over to 1:30 too.
Okay, so Mr. Holland and Mr. Brown both set to 1:30.
Yes, sir.
Okay. Then you have a couple of other matters still, it looks like, Mr. Campbell.
Let me go pull my files and see that. I have to go talk to Cheryl Sue.
Ms. Lawson is here in the back.
Is there anybody else in the courtroom in Zoom? Mine and Miss Sue?
Miss Sue is no longer on Zoom. She's
She's in breakout.
okay.
Miss
and then-
Lawson, if you want to just step out, I'll be right there. Thank you much.
Be a busy afternoon.
Yeah.
Ma'am on the aisle, what's your name? Ms. Richardson.
Oh.
You were in arraignment this morning. You were scheduled at 8:30, ma'am. Okay, let's bring her. Come on up, Ms. Richardson. All right, ma'am. So can you state your name and date of birth, please, for the record? Okay, Ms. Richardson, you are making a first appearance arraignment on a charge of flip license plate violation or false registration violation. This is what is called a simple misdemeanor in the state of Washington. It's subject to 90 days in jail and a $1,000 fine. I have reviewed the associated police reports with the case, and I have found what is called probable cause. Probable cause simply means that we have enough at this point to enter a plea. Because this is a criminal charge, ma'am, you have several important rights, including the right to remain silent, the right to a speedy and public trial, and the right to an attorney. You have to be screened today, ma'am, for a court-appointed attorney.
Yes.
Okay, yeah, so we're being recorded, so we have to say out loud, even if we're nodding our head. Okay. So Ms. Richardson, I'm just going to ask you briefly, do you receive any manner of state assistance in either Washington or Oregon? Okay, that would constitute state assistance. Court will assign. Okay, we're going to assign Ms. Ingstrom. Is Ms. Ingstrom still here? I think she is. Oh, she's with the defendant. Okay. So Ms. Richardson, we're entering a not guilty plea at this time. That's going to preserve all your rights. We're going to set 2 future court dates. The first is going to be on the 26th of April, 2023. And that's a date where your attorney, Ms. Ingstrom, is going to be able to communicate with the city attorney to discuss your case, not a required court date for you. Your next mandatory court date, ma'am, is going to be on the 25th of May, 2023, and that's going to be at 10 o'clock in the morning. If you fail to appear at that time, a warrant for your arrest can be issued. Conditions of release: violate no laws, notify the court of any change of address or phone number, and not to drive without a valid license and insurance. You are being released today, ma'am, on your recognizance. You've been in good contact with the court. I know that there were some issues last week too, so that's okay. So Ms. Ingstrom is going to be able to be in contact with you. Is there a phone number I can write on the form here so she can reach you?
541
541? Okay.
306
Mm-hmm.
0940.
Okay. And then we'll write Ms. Ingstrom's contact number on the form as well, so you can be in touch with her, okay? We're gonna get you some paperwork over by the door, ma'am. Once you have your papers, you are free to go. Thank you, ma'am. Have a good day. So I guess we have Ms. Lawson and Ms. Sue. We have a couple more.
Can we call the Cheryl Sue matter?
Okay. Let's make sure. In the breakout room still?
Oh, she may need to be pulled out of the breakout room she was in with me. If she doesn't know how to do that, to leave the breakout room.
Ms. Cammer, can you close the breakout room that Ms. Sue's in to bring her back into the main session? Thank you.
Yes, Your Honor. Sorry, I was filing.
Not a problem at all.
Unfortunately, it does take 60 seconds for those rooms to close.
All right, Ms. Sue, can you hear the court, ma'am?
Yes, sir.
Thank you. Can you state your name and date of birth, please, for the record?
Cheryl Sue for 1880.
Thank you, Ms. Sue. Your attorney, Mr. Campbell, is with us here in court. Go ahead, Mr. Campbell.
Your Honor, this is a circumstance where my client has been working towards some mitigating information, just in all fairness, attempting to get back to lawful licensure status. And so we are hopeful to waive this matter out to May 11th. I think that by that time, hopefully she has got some mitigation information for the court. She's aware of her constitutionally protected rights for a speedy trial and is hopeful to waive those rights out that day in order to be able to take advantage of negotiating this case.
Couple questions for you, Ms. Sue. Do you understand your right to a speedy trial?
Yes, sir.
And are you in agreement with starting or beginning that speedy trial right again on May 11th, 2023?
Yes, sir.
Okay, that would give the city of Richfield 90 days from that date if it became necessary to bring you to trial. I will accept the waiver. I'll find it knowing, intelligent, and voluntarily made. Ms. Sue's next court date is May 11th, 2023 at 10 o'clock in the morning. Please make sure, Ms. Sue, that you are staying in touch with Mr. Campbell. We're going to be mailing you some paperwork, ma'am. Are you still getting your mail on Settler Drive in Richfield?
I can, yes. Yeah.
All right, we'll send the paperwork there. You can go ahead and log out.
All right, thank you. Have a great day.
Thank you, you too.
And then Judge, my Miss Lawson was on an important call with the Housing Authority. Can I step out real quick and see if she's ready to proceed?
Sure. Ms. Ingstrom, are you ready on your matter? Okay. Good morning, ma'am.
Morning,
And if I could have you just state your name and date of birth, please, for the record.
Veronica, Vespache, 179.
Okay. So Ms. Ruscache, by the paperwork I have in front of me, it looks like you're entering pleas today to two charges, a plea of driving while suspended third degree and a plea of theft in the third degree. Is that your understanding?
Yes.
Okay. Have you had plenty of time to go over your paperwork today with your attorney, Ms. Ingstrom?
Yes.
Okay. I'm going to try to do this plea kind of at the same time because we're going to go over a lot of the same information. If it's not working out or you get confused, I can do them each individually. Okay.
Okay.
All right. So on one case, which was, let's do this in chronological order. So the first case you're entering a plea on is 19-12-001. This is a theft in the third degree case taking place in 2019. At that time, it does appear that your name on the citation is Veronica Rijique Lopez. And then the other charge we're entering a plea on is 2A0106-714. At that time, it's just Regis K. Is that your understanding?
Yeah, my name has always been requested, or I've been over the battleground.
Mhm.
Local is a maiden name, so I would be looking in a while.
Okay, all right. You're 34
Yes.
and you've completed 12 grades in school.
Mhm.
You're able to read and understand the English language?
Yes.
Okay. In entering your pleas today on both cases, you are giving up some important rights that you and I are going to review together. You have the right on both cases to a speedy and public trial by an impartial jury in the county where the crimes alleged to have been committed. You have the right in both cases to remain silent before and during trial, and the right to refuse to testify against yourself. You have the right on both cases to right at trial to hear and question the witnesses who testify against you. You also have the right at trial to testify and have witnesses testify for you, and it can be made to appear at no expense to you. You're presumed innocent unless the charge is proven beyond a reasonable doubt or you enter a plea of guilty, and you have the right to appeal a finding of guilt after trial. Do you understand that those are your rights on both cases?
Yeah.
You understand that entering your pleas today, you're waiving or giving up those rights? Okay. The charge of driving while suspended in the third degree is what is called a simple misdemeanor. It's subject to 90 days in jail and a $1,000 fine. The theft in the third degree is what is called a gross misdemeanor. It is subject to 364 days in jail and a $5,000 fine. There is a pretrial agreement that takes into account both cases. Do you understand the court does not have to follow anyone's recommendation as to sentence, but can sentence you up to the maximum on both?
Right.
Okay. Both cases have a probation term of 2 years, during which time you can pay cost, fees, and assessments as authorized by law. And in both cases, if you are not a U.S. citizen, a plea could result in immigration or deportation issues. All right. On cause number 19-12-001, the charge of theft in the third degree taking place December 6th, 2019, in the city of Battleground, Washington. How do you plead? Are you entering this plea freely and voluntarily?
Yes.
Has anyone made any threats or promises to get you to plead guilty?
No.
The factual basis states on December 6th, 2019, in the city of Battleground, Washington, I wrongfully obtained unauthorized control over property of Walmart for a value of under $750. Is that a correct statement?
Yes.
Okay. I will accept the plea, find it knowing, intelligent, and voluntarily made after advice of rights and advice of counsel. On cause number 2A0106714, that is the charge of driving while suspended in the third degree, taking place January 19th, 2022 in Battleground, Washington. How do you plead?
Guilty.
Are you entering this plea freely and voluntarily? Has anyone made any threats or promises on that case to get you to plead guilty? Factual basis states on January 19th, 2022 in Battleground, Washington, I operated a motor vehicle while my license was suspended. Is that a correct statement?
Yes.
Okay. I will accept the plea on that case, find it knowing, intelligent, and voluntarily made after advice of rights and advice of counsel. What's going to happen now, Ms. Regis K, is I'm going to hear from the city attorney. I'm then going to hear from your attorney, Ms. Ingstrom, and if you want to address the court, you can as well. Okay.
Yes,
Ms. Carney?
yes, Your Honor. These cases have been pending, as Your Honor can see, for quite some time. We would ask the court to follow this recommendation, given that any lesser sanction, essentially, we don't believe would be complied with, given the history of non-appearance in this case, which is why we are requesting the jail sanction. In addition, I believe as part of this plea, did you already hand up the dismissal?
I have not yet.
Okay, there is a dismissal to the 9Z case as part of this plea. Otherwise, we would ask Your Honor to follow the recommendation.
All right. Pursuant the agreement of the parties,
Oh,
I am dismissing 9Z0685-174.
your client.
And I'm signing off on that right now. Go ahead, Ms. Ingstrom.
Your Honor, this, obviously, these are a little bit older of cases. There's definitely a history of some non-compliance problems. She is trying to pull it all back together. She was released out here earlier, I believe in March. Her daughter had gone missing. Her daughter is now back. But there are sort of ongoing issues with that. I believe she wants to address the court. I believe she's making an attempt to put this behind her as best she can.
The only question, so the PTA I'm not seeing. I have all of the other forms though. Judgment and sentence, I have both plea forms, I have the dismissal form. Okay, thank you. I just would like to have the PTA in front of me before I hear from Ms. Richike. Is there a criminal trespass charge that was also being dismissed?
Yeah, and under the 19, the docket never started in 19, we're dismissing charge number 2.
Let me go and amend that physical citation. Now, it looks like that was maybe count 1.
Oh, okay. I have it backwards on the PTA.
All right, thank you. All right. Okay, I have amended the filed citation indicating dismissal of count 1. And a plea to count 2. Okay, Ms. Rijike, go ahead.
And Your Honor, before I forget, I would
Sorry.
also ask for you to do a Zena analysis of this on the fines.
Understood. Go ahead, ma'am.
Okay, no, I was just wondering if there's no chance of work proof, just due to my daughter running away like the last time I was in jail and no one knowing where she was, the cops were looking for her, they couldn't find her. And it's just a chance that she's gonna do it again if I end up going back to jail. And this time I don't want her to be somewhere that she shouldn't be. She's only 14 years old. And it's already hard for her and I'm trying to do good for her. And I thought that the last time I was in jail, they did a global, I thought that included all these. And that was kind of federal. I had way more than. So I'm confused on that part there.
So if all those issues are in place, why are you entering the plea today?
I was confused. I didn't know, honestly, I didn't know if that, she told me that it wasn't part of that jurisdiction, so that's why.
I understand, but you're entering a deal today to dismiss some of your charges. But jail's part of that agreement.
Right,
So why are you entering an agreement that you're not wanting to enter?
well, if I was hoping to do work groups, I don't have to go back to jail.
But I understand, but the agreement to dismiss your charges have you do jail.
Right, because she said the work crew wasn't an option. So I was just trying to make sure if that wasn't an option, I can.
But I guess what I'm saying is that that's something that's negotiated with the city. That's not something, generally, when someone brings a case in front of me and says, these things are all being dismissed, right?
Mhm.
The theft charge is being dismissed, criminal trespass charge is being dismissed. You're getting a benefit from having those charges dismissed, but part of that benefit is you have to accept the other terms of the agreement.
Right.
What you're asking me to do is you're wanting to get the benefits, but you're not willing to
No,
follow.
Like, literally, like, I just wanted to make sure I don't go back in and my daughter goes missing.
But this deal is putting you back in.
Yeah, like.
Then why are you can't do both. You can't say, I want to get these charges
Right.
dismissed and I don't want to do the sentence that I'm agreeing to. This is the sentence you've agreed to.
Okay. Okay.
I mean, that's how it works.
Yeah, yeah, I actually, didn't matter enough. So, well, yeah, go ahead.
Okay. Well, who's going to care for your daughter when you're in jail?
I'm hoping my mom will,
Okay,
because she went missing when she was with my mother, so.
okay. Well, do we want to schedule out your time to do the jail a few weeks so you can get that?
That would be nice.
Okay, let's do that. Again, what I don't want to see, this is not a circumstance where you enter a deal and then you try to renegotiate the deal with the
Right.
judge. My job is just to facilitate whatever's going on between yourself and the city,
Right.
okay? But again, I'm sympathetic to your circumstance. I'm glad your daughter's back. I don't want there to be a future issue, so I'm going to try to give you some time before you have to report to hopefully have that not take place,
All right.
okay? Okay. And it looks like, is there actually a recommendation then? Because the EWS 3 case is not on this PTA.
There was 2 PTAs and the DWS is a 1 day and then the theft was a 10.
Okay. All right. And then you asked me also to inquire as to Ms. Rijike's finances.
Yes.
Are you employed right now, ma'am?
No,
Do you receive any manner of state assistance at all?
yeah, I do.
Okay. Do you have any income in your household at all?
No, I'm considered homeless.
Okay. Well, I am gonna find that you do, I will under Blazina waive all the fees and costs. So let's go through the plea paperwork. On cause number 19-12-001, that is the charge of theft in the 3rd degree. We did dismiss the criminal trespass charge. It is 364 days with 354 days suspended. That is 10 days to serve, in the Skamania County Jail. Jail is done in Skamania County. Do you know where Skamania County is?
No.
Do you know where Stevenson, Washington is?
Mm-mm.
Do you know where Washougal is?
Yeah,
You go to Washougal, you drive east on SR 14, which is the main highway that goes through Camas and Washougal.
Mhm.
You keep going east, you will eventually end up in Stevenson.
okay,
Jail's right up on the left-hand side up on the hill.
okay.
Okay. I think we have an address when we do a jail form that for that jail, hopefully. We're gonna set a report date and a report time that you'll have to be there. Do you have picture ID?
Yes,
Okay, you're gonna bring your picture ID with you along with the form we're gonna give you.
okay.
Do you have access to a calendar right now?
On me, no.
Do you have it on your phone, Ms. Ingstrom?
Yes.
Let's look at a calendar and you can tell me the date and time that you want to report, okay? I want you to be able to see a calendar so you can figure out a day that will work for you.
So maybe, let's say. Friday? Mhm. Yeah,
April 28th.
yeah, I think that's right there, right? Yeah. Yeah, let's do that day.
Friday, April 28th.
28th, okay. And you can be early at whatever time you set. You can't be late. What time do you want to report by?
When's the latest I can report? You know,
I think the latest they want them showing up in Skamania is 6 p.m. Am I right about that, Madam Clerks? So before 6 p.m.
okay, say 5, just to make sure.
I'm gonna do 6 PM and you can be early. How about that?
Okay, sounds great.
All right, by 6 PM. Do the 10 days. I'm not gonna impose another jail day on the DWS. I'm gonna just go with 10. I think you're getting a big benefit, but I also understand your concerns as a mom, and I don't want to prolong this any more than we have to.
Thank you.
I'm not going to impose any fees or costs. Bench probation for 24 months. No contact with Walmart. I'm not going to impose the theft class. This was in 2019. She hasn't done, I don't think there's been new thefts since that time. You can correct me if I'm wrong, if I'm not misreading the DCH, but I just don't want to set her up with more conditions that we might not be able to meet. Because of that, Madam Clerks, I'm not setting a review date. As long as she shows up and does the 10 days in jail, I'm going to be satisfied in that circumstance. To the 2A010-010-6714 DWS 3, 90 days with 89 days suspended, 1 day to serve. I am going to say that is running concurrent with this charge. Checking again still on 4/28/23, no later than 6 PM. I am going to find a $1,000 fine. I'm going to suspend all of the fine. 24 months bench probation, no additional charges. I'm not setting again a review date. This is about as streamlined, Ms. Rijike, as it can be. Just do your 10 days. They'll give you a good time calculation. You'll probably do 6 or 7 overall. Hopefully we're giving you some sufficient time so you feel like your daughter's in a safe place with your mom. And I think that's about it. I think that you are getting a very significant reduction on behalf of the city. So I think that they're meeting you halfway here.
Right.
And I just think it's important that you go the other halfway. So, but I do wish you well, ma'am. This is your jail form I'm going to sign in a minute. You need to have this with you with your picture ID.
Okay.
And I would note on here, there is not the address for this Canadian County Jail, but we have a form that we'll give you, or we'll give you that address as well. Okay, ma'am?
Perfect, thank you.
No problem. Do you have any questions at all about what's taking place in court today?
No.
The good news is this is all going to be behind you now. This is the last step,
Right.
okay?
Thank you.
Good luck, Ms. Rijike.
Thank you.
All right, take care.
Thank you, Judge.
Yep. Yikes.
Is Mr. Bernard on, Your Honor?
Say again, Mr. Busby?
Kylie Bernard. That was the other readiness that I had on.
Bernard is not here. Kylie Bernard.
I believe that was assigned to Mr. Campbell a couple of weeks ago.
Okay. It looks like we were never able to send out notice. We did not receive a new address.
He was online, Your Honor, at the last hearing. He did appear.
Yeah, I recall. Mr. Campbell's not in the courtroom right now, Mr. Busby. Why don't we do this? Why don't you give me, so you can go about a little bit more of your day, give me your recommendation, and then we can email you what I decide once I hear from Mr. Campbell.
At this point, Your Honor, this Mr. Bernard has been attending his hearings. The case is fairly old, but there was a potential global resolution that I had been working on with Mr. Cheney before he withdrew. And so I think we just asked for a warrant in the standard amount, note the FTA at this point, because I don't know where we are with Speedy. And so that would be my concern.
Okay, sounds good. I have that notation, Mr. Busby, and when Mr. Campbell's back in the courtroom, I will pass that along. And yeah, are you with us this afternoon?
I will be, Your Honor. I think I have a show cause or two that might actually need my appearance.
Okay, sounds good. We'll see you then.
Thank you.
So at this point, are we waiting on Mr. Campbell and Ms. Lawson, I'm assuming? Can we go out and get him so we can get that matter called? Thank you, Ms. Carmen. Appreciate that. I think Ms. Carmen went in the back. He's right outside that door. I think he's right out here.
Oh, I was like.
Yeah. Yeah. I can hear him talking.
Oh, sure, yeah. I was very good,
No, that's okay. Sorry, and then do that and then we can go on.
that's perfect, I didn't realize the other night was done, I'm sorry.
It's all right.
Multiple sticks in the fire there.
Yeah.
Ms. Lawson, you want to come up? Ms. Lawson makes her way forth, having had opportunity to take advantage of speaking with me about a recommended stay offer that she'd like to avail herself of, and the pleadings associated with that are right in front of you.
All right, Ms. Lawson, can I have you state your name and date of birth, please, for the record? Ms. Lawson, as you heard me have told other people this morning on these stay agreements, I'm not a party to the agreement. This is a contract between yourself and the city of Battle Ground. My job is to make sure you understand the terms, meaning the things that you have to do, and then I enforce on the back end the dismissal of your charge if you do what you're supposed to do, okay? With that said, we're going to review the terms to make sure that you have a good understanding. You have some fees and costs, $150 filing fee, $150 supervision fee, and a $300 public defender recoupment. That's $600 that you're paying over the time on a payment plan on the case. You are to maintain compliance with that payment plan. I am going to mark box number 7. It wasn't marked before. You're to do 16 hours of community service. You need to provide documentation on the letterhead from the agency you do community service with. I'm going to see you in 3 months. I want the community service done by the next court date, okay? It's not too much community service, 16 hours. You can knock that out, okay? No contact with Walmart, no new criminal charges. You're to do the theft awareness class. You are giving up some important rights in entering your stay today. You're giving up your right associated with having a jury trial. Do you understand that right? And you're understanding that you're giving up that right to do the stay today? Are these your initials right here? Okay. You're also waiving your right to a speedy trial. 2 questions. Do you understand what your right to a speedy trial is? And are you in agreement to have that waiver start April 13th, 2024? All right, and these are your initials again here. Okay. Charge which you are entering your stay on is a gross misdemeanor, subject to 364 days in jail and a $5,000 fine. We are setting a review date for July 13th, 2023 for me to see that alternative community service is done and the theft awareness class. The best way to not have to come to that court date is to have those things on file with our court. We can cancel your appearance that day. Your final court date is going to be April 11th, 2024. At that time, if you're in compliance, I'll dismiss your case. Okay. Any questions for Mr. Campbell or myself before I sign you into the stay? All right. He's signing the document. We're going to get you a copy of the document, Ms. Lawson. If there's no other further questions, I wish you well on your stay. And hopefully we don't even have to have you back here in July because you have everything done. Yeah. All right, ma'am. Good luck. Have a good day.
And then, Your Honor, I have on my, I'm not sure if this is.
Kylie Bernard.
Yes, that's
has not shown up. I did talk to Mr. Busby. He's requesting a warrant in the standard amount.
I don't have any information for the court.
All right. So Kylie Bernard was scheduled for this morning, cause number 21-6-0001. Cause number C 41399. I am going to find that Mr. Bernard has failed to appear, warrant authorizing the standard amount on both cases. And I think with the set overs at this point, that does conclude our morning docket. The clerks want to just give me a head nod or verify. All right. All right, this time we can go off the record and we'll recommence at 1:30.